lovely afternoon. On the occasion of the Indian Constitution Day, Center for Civil Society, in an effort to institutionalize the repealing of laws as a constitutional practice for the Republic of India, has brought together like minded organizations, scholars, academicians, and lawyers to acknowledge 26th November as the National Repeal Law Day. The objectives of this National Repeal Law Day are to celebrate the diversity of our legal system, take stock of repealing processes, and have a constructive dialogue around the processes of repealing laws, and to build a conversation around the necessity of a sunset clause in the Indian legislative processes. Over the next few hours, we will engage in an insightful discussion and hear from thought leaders who are dedicated to creating a more robust and transparent legal framework for India. Let us begin. To formally kick off today's proceedings, I'd like to invite Dr. Amit Chandra, the Chief Executive Officer of the Center for Civil Society, to deliver the welcome address.
Thank you so much, Bhavya. And also my thank you to the entire organizing team at CCS for putting up this gathering on the right day, which is the National Constitution Day. Um, and this is an effort towards, um, it's an appeal highlighting if this day could also be observed as the National Repeal of Laws Days. Um, and as I come to the key theme of the discussion or the key theme of the event, the first thing I would like to mention as to why, uh, what is it that the Center for Civil Society does, and why do we think this part of work is so core or so important to us. As many of you would know, CCS envisions a world where individuals are free or have right to choose as many things as they wish to do, and institutions are accountable. So the ideal world that we envision is where individuals can exercise the freedom to do things that they desire, they find necessary to live a happy and prosperous life, and institutions which actually individuals choose to create are accountable towards the citizen. And that's the larger vision that guides everything that we do at CCS. And when we think of this vision, which is which in some sense presents the framework for what we say good governance. Now, many people here or outside this hall would resonate with the idea of minimum government, maximum governance. Our Honorable Prime Minister also gave this call, and why it is important, why this slogan is important. Because basically, many of us have realized that we have too many of laws, but too less of governance or too less of justice delivered. So, can we think of that the India or a society or a state where we have less but very clearly written law that helps us improve the quality of life for every individual or every citizen. Now, so that is why CCS thinks that it is important to work on a process like repealing of laws. So, as in India, as I mentioned, we have too many laws but too less governance, and therefore we also have many pending cases in courts, right? And therefore, in this exercise, what is the ideal thing to achieve? The ideal thing to achieve as we started working on repealing of the laws project, we thought there are laws which are redundant today or obsolete, which is not required. So, can we review some of those laws, and something which has, in some sense, expired, outdated, can we simply remove it? So that was the guiding thinking behind it. But then we also started thinking that CCS or many other partner organizations, we are small organizations with limited capacity or limited access to this knowledge of how many laws we have, how it can be repealed, etc. It is basically an exercise to be conducted by the state. So basically we wanted to demonstrate that this can happen, and actually state is the rightful authority to lead and conduct this. And therefore, can we present a model, an easy workable model for the state to institutionalize the process? So whenever today the winter session of parliament begin, and every time the parliament is sitting or state assemblies are sitting, they're passing new laws. So the idea we started exploring, that could there be at least one day dedicated when parliament or assembly will sit down to look at what of the laws we created has either achieved the objective or has become redundant, or is not achieving the desired objective that it was ought to achieve, and therefore those should be repealed. And this is why we thought 26th of November could be one rightful occasion to talk about it and highlight it. And if many organizations working in network, states, the civil society, media, if everyone likes it, we may start slowly observing the Constitution Day, 26th of November, as the repeal of the law day. Um, Now, before we begin the other parts of the conversation, there are a few ideas that I want to briefly touch upon in my welcome remarks. The first thing is that at times I have contemplated or debated with my friends and my fellow colleagues is this idea of sovereignty, which is the core for a state, and therefore the constitution is required. So, in a very rudimentary way, what why the state and why the constitution, assuming all individuals on in our country or on this planet are born free. However, this freedom could also lead to chaos, and therefore we need some kind of order in society, and what there should be a guiding book to run that order, right? And therefore we decide create state, and we give some power to control and regulate ourselves, right? So in some sense we give away part of our liberty to the state, to the institution, so that they help us run society in a better way, and therefore sovereignty of state becomes important. But, and this is the point I want to make, the sovereignty of state is to actually protect the sovereignty of individuals, right? So citizens become very core of the design, and therefore any policy framework we are designing, we should always keep in mind the citizen. So for an example, when we work on education or education related projects, we always keep student at the center of the policy framework. When we are thinking about agricultural policy, we keep farmers at the center of our policy design. And therefore, in the when we are talking about constitution, state, and why sovereignty of state is so important, at times I believe, in my experience, I have observed that sovereignty of individuals are undermined, and therefore I wanted to highlight that we should always keep in mind that sovereignty of state is to protect the sovereignty of individuals. The second thing, I'm throwing these ideas, and it's not that I have my final conclusion, but hopefully it should create enough debate among the wiser people sitting here in this room. Is sometimes I have debated with my colleagues, what are the guiding values of our constitution in India, which is justice, liberty, equality, fraternity, right? JLEF. These are the guiding values which actually, through the preamble, in some sense influences almost everything, all the articles, all the sections, all the provisions. And this is not just for India. If you look at the constitution of many other countries also, at the core, you will find these four words: justice, equality, liberty, fraternity in different formats or the other. What we have wondered, if would India after 75 years of independence look the same if we change the order? The order is, the supreme is justice, then liberty, then equality, then fraternity. If, let's say, I put liberty on top of it, so I say liberty is the supreme value, then justice, then equality and freedom, or you can create your own order. And then at times, this is a quick just game that I play with my friends, and I ask them to put these words in order of their preference, which you can also run as a quick exercise and see how, based on your own values, how do you want to put in an order. And if that is the order, would India look the same or somewhat different, and different in what manner? Um, the another thing I would like people to contemplate is, Nitesh, please remind me if I'm running out of time. So I'll keep it very brief. Whatever is, so far I was talking about past, yeah, 75 years में क्या हुआ और क्या कर सकते हैं वगैरह वगैरह. But now we have all have to be forward looking people. We have to think about the future. जो हुआ हुआ, अभी आगे क्या करना है, that should be our core concern, right? And therefore, one of the core goal, which is and which must guide us, is what once again the honorable prime minister is targeting, that let's envision to put India as a developed nation by 2047. जब 100 साल होगा हमारे इंडिपेंडेंस का, उस समय तक क्या हम विकसित भारत बन सकते हैं? And once again, in that light, once again I would like to explore, would the constitution or the constitutional framework we have would allow the fast economic growth, जो कि अभी शायद ही कहीं पे हुआ होगा, एक्सेप्ट द एक्सेप्शनल्स, कि हमें हर साल फिर लगभग 11-12% का इकोनॉमिक ग्रोथ चाहिए. और अगर हमारा कॉन्स्टिट्यूशन या प्रोसेस वो कुछ डिजाइन ऐसा है विच मेक्स थिंग्स स्लो और टाइम लगता है, तो मेरा प्रश्न सीधा सा होगा, जो कि वंस अगेन आई एम थ्रोइंग दीज क्वेश्चंस एंड आइडियाज टू ऑल ऑफ यू to contemplate whether my constitution is compliant to deliver fast economic growth of 11%, which will help me achieve it, or if it is not, I mean, and therefore the ease of doing business and etc., all that concept comes. क्योंकि इस गोल में, इस एस्पिरेशन में हम अकेले नहीं हैं, राइट? And the most important, the other contenders are the BRICS countries, right? Brazil, Russia, the other big economies who are aiming for fast growth, and they also wish to be developed nations, or some of them are developed nations. तो हम अकेले ही नहीं हैं, और भी देश हैं जो फास्ट प्रोग्रेस करना चाहते हैं, and we have to compete against, and therefore we should also look at how competitive is our constitution, which allows individuals or people or industry to flourish, to deliver fast economic growth, so that practically we achieve it. And my final point is, all of these becomes very meaningless when citizens have to struggle for डे टू डे एक्टिविटीज, और लेट्स से बेसिक अमेनिटीज. तो अगर हम फील्ड में जाते हैं जहाँ पे देखते हैं कि बच्चों को सही शिक्षा नहीं मिल पा रही है, या नल में पानी नहीं आ रहा है, या स्कूल में टीचर अवेलेबल नहीं है, या हॉस्पिटल जाते हैं तो डॉक्टर नहीं है, देन पूरा ये फ्रेमवर्क एटसेट्रा इट बिकम्स वेरी मीनिंगलेस, राइट? बिकॉज एट द कोर ऑफ everything once again is the citizen who has to be taken care, empowered, being accountable. तो उनके साथ होना है, और वो अगर नहीं हो रहा है तो सब कुछ मीनिंगलेस हो जाता है. एंड देयरफॉर आई विल like to connect this entire exercise of constitution, constitutional framework with ease of doing business, finally resulting into ease of living for the citizens. That is where I would give a pause to my welcome remarks. Thank you very much to all of you for coming on a working day. Um, Thank you very much.
Thank you, Amit, for your words. Definitely, we have a lot of interesting ideas that we'll be contemplating now. Next up, we have the honor of hearing a special address from Dr. Neeti Shikha, Corporate Law Faculty at the University of West of England. Dr. Neeti Shikha holds over a decade of experience in researching and teaching in the area of corporate laws and governance. She holds a PhD from the National Law University, Jodhpur, and has completed her LLM from University College London, UK. Neeti is also a board of advisor at CCS and has held academic positions at various law and business schools in India and Singapore.
Project. Namaskar. I'm Neeti Shikha, and it has been an honor to be associated with CCS as a former coordinator for the Repeal project. When Arun Shuri in Anita Gets Bail exposes scathing critique of Indian legal system and calls for urgent reform, he emphasizes the need for the judiciary to prioritize efficiency and fairness to restore public trust and rule of law. But look at our courts today. It is plagued with delays. Justice delayed is justice denied. But just like the one you may have read in Charles Dickens' famous novel Bleak House, where efficiency and cruelty of English Chancery's court focusing on how endlessly legal delays destroy lives, it makes us rethink about rule of law. In a strong and civil society, one should not be forced to go to courts for justice. It should flow from rule of law that is fair, reasonable, and predictable. Delay in judicial processes are often result of unclear, vague, or overtly complex laws. When legal provisions are not clear, it causes conflict amongst judges, lawyers, and litigants. This lack of legal clarity only hampers the efficiency of legal proceedings. It undermines the delivery of timely justice. Benjamin Cardozo's famous quote that law must be stable, but it must not stand still, makes us rethink about the whole processes through which law is made and updated. First and foremost is to clearly defining. First and foremost, it is important to constantly audit and reform rule of law. First and foremost, it is important to constantly audit and reform rule and rule of law. Several countries regularly audit their old laws and repeal the obsolete ones as part of the legal and administrative reform processes. UK, for instance, has a systematic approach for repealing obsolete laws through the Law Commission. The Commission reviews and recommends laws for repeal based on public interest and its relevance. In 2015, the Statute Law Repeals Act repealed over 800 laws, including obsolete railway regulations and outdated restrictions on trade. There are regular updates, stakeholders' consultation, and public engagement to ensure that the legal framework stays modern and efficient. While in the US, there is no centralized repeal mechanism, laws are regularly reviewed at federal and state level. Sunset clauses in legislation automatically phases out certain laws unless renewed. Repeal of Prohibition era laws like Volstead Act of 1933 are examples of how US has made sure that laws remain modern. Australia's statute update bill process reviews and consolidates laws. In 2020, the Australia's parliament repealed redundant laws relating to trade practices and financial regulation. Canada, too, uses periodic reviews and omnibus repeal bills to streamline the legal framework. In 2018, Canada repealed outdated laws that criminalized witchcraft. New Zealand has adopted similar robust procedures. It repealed outdated tax laws and early 20th century trading restrictions. Singapore, known for its efficiency in governance, regularly revises the laws to align with contemporary practices. To give you an example, in 2019, Singapore revealed the Estate Duty Act as a part of efforts to simplify taxation, with a clear focus on economic competitiveness and legal clarity. India too has taken significant steps in recent years to identify and repeal colonial era laws which are redundant. The process has been spearheaded by the government and the law commissions. Between 2014 to 19, over 1,500 outdated laws were repealed, including the Ganges Toll Act of 1867 and Salt Cess Act of 1953. Why do we need to repeal law? Well, because they might be redundant and may not be fit for its purpose or for the time. Think of the manual regulation in digital era. Laws requiring businesses to make a physical copy makes no sense now that digital storage is in practice. India's Telegraph Act of 1885 may not serve the purpose of today's modern telecommunication technologies. Hence, countries have to constantly audit and repeal obsolete laws. When they do that, they show their strong commitment to maintain a dynamic, relevant, and fair legal framework. While the approaches may vary, but common element, which is centralized review commissions, public engagement, and a periodic legislative updates remain same. The Center for Civil Society initiated Repeal of Law project in 2014.
We thank Dr. Neeti for her words. Now, let us take a look back at the impact and achievements of CCS's decade long Repeal of Laws initiative. To present this, I invite Mr. Nitesh Anand, Senior Fellow for Policy Impact and Outreach at the Center for Civil Society. Nitesh, please join us at the podium.
Uh, Thank you, Bhavya. So, actually, today completes 10 years of our effort of repealing of laws and the kind of initiatives we have run over the years. And this is a very special moment for me personally, as well as for whole of CCS. And it's a pleasure for me to walk you through the kind of things that we have achieved and what have we done over the decade. And this is my attempt to share with you the things that we have done at our end and the vision that we have for the upcoming future, especially in the recent future as such. So let me start by sharing this fact with you. Uh, did you know that nearly 12% of indigenous bulls breeds in Karnataka are at risk of extinction, partly due to forced castration practices raising greater issues on animal rights and welfare? Does it sound bizarre? Why, why is that happening? Well, it's because there is a law which mandates it, and which in which is basically the Karnataka Livestock Improvement Act of 1961, uh, that mandates castration, and this act disregards the well-being and natural rights of animal, particularly the bulls, and raises significant ethical concerns regarding the treatment of these animals. This also gives power to the licensing officer excessively, which is contradictory to the rights of the animals, and promotes invasive procedures without addressing the broader concerns of animal welfare, and it has been in existence. So there are different laws like this which have been in circulation, in practice, or at least which exist in our astute books. So basically, when we came across such laws, we realized that okay, this is something which needs our attention, and that's where we decided to work on identifying laws like that in order to first the idea which made us curious when we started deliberating about it, we realized that okay, it's while something started with curiosity, but it actually is a vast ocean of endless and number of laws which needs our attention, and probably we can become the medium for propagating these and identifying and propagating these to the audience in the common public as well as in the legislative assemblies and parliament. So that's where we realize that India has several statutes which has become obsolete, redundant, or repetitive. And additionally, there are also certain inconsistencies in language and dissemination, so which is also making it difficult for an ordinary citizen to access and comprehend legal information with ease. We realize that there are the impact of these statutes are very vast and on the society as well as economy. Impacts like legal uncertainty, judicial overburden, erosion of trust between the sovereign and the government, human rights violation, reduced ease of doing business, increased transaction costs. We also identified that such laws often block social progress, and they distort the competitive dynamic of the economy. So, in order to address this, we started in 2014, exactly 10 years before today, the Repeal of Laws initiative with the objective of drawing attention to the critical need of legislative cleanup, especially by engaging policymakers, uh, leading law experts, legal researchers, academicians, and civil society at large. So, with that ambition, with that objective, uh, we started identifying and creating a list of laws which could be repealed on account of three primary reasons: redundancy being the first one, obsolescence in face of new laws being the second, and hindrance to development, governance, and freedom being the third. So these three were the primary lens that we used in order to identify the list of laws. So in 2014, we started this 100 laws project of the central legislation, uh, which had a range of archaic British era laws. And this initiative was actually done in partnership with NIPFP and Vidhi. We are glad to have our friend from Vidhi also join us, and you will be listening to them in the panel. So at that time, when we started with these 100 laws, we realized that okay, yeah, this was a good exercise. When we got some significant success, when we got mentions in law commission's report, and a big number of laws got repealed immediately, and subsequently lots of the remaining ones also got repealed. We realized that okay, while it's good to look at the central legislation, can we also see that how's the status in different states? So in 2015, we took the next step and decided to look into the legislations in two specific states, Delhi and Maharashtra, where we collectively identified 55 laws, and then the journey of having developing these compendiums at state levels continued. In 2017, we did the second set of identification for the state of Maharashtra, and the first set for Karnataka, Chhattisgarh, Telangana, Uttar Pradesh, uh, identifying 133 laws. In 2018, 183 laws in states of for states of Jammu Kashmir, northeastern states of Meghalaya, Tripura, Assam, and Mizoram, and Gujarat. In 2019, we did another compendium of identifying 150 laws for the states of Arunachal Pradesh, Assam, Sikkim, Manipur, Meghalaya, Mizoram, Tripura, and Nagaland. The state level research was done in partnership with the leading law universities, mostly in these respective states, and where there are no law universities that we could find partners, we found another law universities in the neighboring states to partner. Alongside these law universities, we also had partnership with some leading law firms in the country who were generous enough to support us with their dedicated team members to review the work of these law students and provide their technical inputs and comments. So, Cadden Boris, where Hemant is part of, which was one of our partners along with AZB and others. And yeah, we are also looking forward to listening to you, Hemant, in the panel. So now that was the process, but how did we actually identify these based on these three components? While we identified the laws based on the three components of obsolescence, redundancy, and hindrance to development, we also took it one step further and started grading the laws. Uh, we started grading the laws on a scale of 5 to 1, 5 making the strongest case for repeal, and one means that there is a relatively weaker case for repeal. Uh, then the factors on which these grades were provided were a, that if the law has been recommended for repeal by any law commission or other government reports, has that particular law faced any judicial criticism. uh, Redundancy and was another factor that we took in our notice, and if there was any subsequent legislation which subsumed that particular law. So, based on these four factors, the grading was processed. And of all the laws that we identified, as you can see in the uh, graph uh, on the left top side of the slide, 246 of laws were actually in the grade 5, which made strongest case for repeal. We also classified them based on different subjects and themes. Uh, a majority of these uh, were from the administrative law, were administrative legal statutes, uh, and there were different themes like agriculture, personal law, labor and services, taxation, financial management, uh, which had the list of laws. Our very celebrated, very important partners who have been part of this 10-year journey at different moments, at different phases, at different points. NIPFP, the National Institute of Public Finance and Policy, uh, NLSIU Bangalore, then NLU Chhattisgarh, Mumbai, NLU Mumbai, University of Jammu, SLS Noida, Nalsar Hyderabad, and GNLU Gujarat, where the institutional partners, where the interns and the students helped us identify and find the laws. Then Cadden Boris Legal, and AZB and partners were the law firms who supported us, and Vidhi and NIPFP were part of the very first compendium of the central legislation that we prepared. We over the period of 10 years, we had 15 plus mentors who were part of this initiative, and 80 plus students and academicians who were directly involved in the process of identification of the legislations that we recommended. So, uh, when we look at the reasons for repeal that we recommended through all these compendiums, Around 178 of these laws were redundant or obsolete. 130 were already superseded by a subsequent legislation. Uh, 67 were identified to achieve its purpose. 39 have outlived its purpose. 45 were deemed directly unconstitutional, and there were others which included different other things. So overall, 530 plus laws were analyzed. 17 different compendiums were released, and as we stand at the 10th year anniversary of 10th year of the Repeal Laws initiative in 2014, since then it has been 10 years. Out of 530 plus laws that we have analyzed, uh, 227 laws have already been repealed, and 303 laws still remain to be repealed. That is the status of our work so far. Uh, Here you can see different laws that have been analyzed in different states. I will not go into the details. You could also find some of these compendiums at the registration desk outside. So if you, and there are also digital QR codes available. So if you want to check this out later, you can do it. Uh, so the project was acknowledged in a report, Obsolete Laws Warranting Immediate Repeal, by the Law Commission of India in September 2014. In the very first 100 suggestions that we made for the central legislation, successfully in the first year itself, 23 central laws were repealed. Uh, CCS reached out to state governments of Delhi, Maharashtra in the very first year, where, uh, especially in Maharashtra, it was an immediate success. And I remember that meeting, the chief minister agreed to repeal 19 out of the 25 laws immediately. That showed the kind of quality that our work had. Uh, yeah. Uh, so, but like if that's the case, if everything is going so on so well, and obviously the remaining 303 will also be repealed over the period of time, but we realize that there are still some laws which are in effect. I'll give you a couple of examples. The Bombay Prevention of Begging Act of 1959 for the state of Maharashtra. This act describes beggars as people having no visible means of subsistence, and it also criminalizes begging, which actually doesn't neither eradicates the problem or nor does it assure any solutions. It also empowers the police officers or any other authorities, authorized person on his behalf to issue arrest, to conduct arrest without warrant of any person who is found begging. Again, like direct contradiction of personal liberty, and which has a potential of rise of power misuse. The local government of in Delhi disqualification of membership small family act of 1996, which is still in existence at the very place where we are having this conversation today, where having more than two children can disqualify your membership to an office under a local government. There are many more. So uh, that's where we realize that there's still a need for rejuvenating, like reconvening and uh, figuring out and creating a strong movement with the objective of reforming the legal structure of the country, especially like how the laws are framed and continued, and especially like about the state capacity also to enable accountable enforcement of these laws when it comes to it. I'll not go into the details of the global practices because I think Niti has beautifully explained uh, some of these, which is mentioned on this slide and even beyond it. Uh, UK, Australia actually had a national repeal law day, which was there in existence for 2 or 3 years, and that's one of the things that we are also proposing from this practice of ours. So looking ahead, what we aim is basically to expand our effort. Now that we are sitting at the decade, it's also a good time to look back, feel proud, celebrate, but also embrace ourselves to move ahead and like put in our energy for the next big effort by identifying more outdated laws and problematic clauses, advocating for inclusion of sunset clause in legislation to ensure periodic reviews. We also plan to extend our focus to cover additional states, engaging with stakeholders across the country to further amplify the importance of maintaining a vibrant and effective legal framework per se. So broadly, in the next year to come, we are planning to build more engaged network of organizations, individuals uh, who would be willing to join this cause and work together with them. Second, we want to analyze more laws because yeah, we realize that the the more we got into this, we realize that there's more which is still to be done. We wish to hold multiple and diverse conversations like this, both in person, online, at different scales, at different platforms, but build more conversations because, as Amit was also mentioning is in opening remarks, that it's important to have dialogue, listen to people, and probably then build consensus around it. So that is something which we aim to do in the coming year. And lastly, but very importantly, we'll be strongly building the campaigns for advocating for sunset clause and institutionalization of repealing per se. So, with that, I request you to join us if you want to join us as research partners or for outreach or for any other activities. Please write to me. Please connect with our team in the room even after the event, and let's join our hands to strengthen our appeal for repeal. Thank you so much.
Thank you, Nitesh, for this comprehensive overview of the initiative's journey and successes. Next up, we have a panel discussion titled From Permanence to Progress, Institutionalizing Repealing of Laws in India. We have an esteemed panel of experts who will share their perspectives and insights on this critical issue. Allow me to introduce the panelists. I request them to please join us on the stage as I introduce them. We have with us Akash Chandra Johri, co-lead of the Corporate Law and Financial Regulations team at Vidhi Center for Legal Policy. Akash specializes in regulatory frameworks and insolvency laws. Prior to this, he practiced law across judicial and quasi-judicial forums in New Delhi. Can we have a round of applause? We also have with us Harshvardhan Tripathi, a journalist with over 25 years of experience. Harsh is an expert on economic and socio-political developments. He frequently appears on CNBC Awaaz and Lok Sabha TV and has been pivotal in producing successful documentaries and TV programs. We have with us Hemant Batra, Senior Legal Consulting Lead for New Ventures and Growth at Shardul Amarchand Mangal Das legal firm. Hemant is a globally recognized lawyer, author, and policy expert. He also serves as Vice President of SARC Law and has collaborated on multiple UN projects. We have with us Niranjana Menon, Senior Analyst at PRS Legislative Research. Niranjana focuses on analyzing parliamentary data and legislative trends. She has co-authored multiple reviews of state laws and holds advanced degrees in mathematics from Christ University and Imperial College London. Please join us on the stage, Niranjana. This session will be moderated by our very own Dr. Amit Chandra, CEO of Center for Civil Society.
Thank you very much, Bhavya, and thank you to our esteemed guests, panelists, who have made the time from a busy day on a working day to be part of this discussion. So, directly jump to the key theme of the discussion. We can keep it bilingual or as people are comfortable. So, Hindi में, English में, जैसे भी बात करना है. I think the key objective is as most people understand. तो जैसे भी वो समझें और जैसे भी आप comfortable है बात कर सकते हैं. The format of the discussion will be, we will have this panel for roughly 90 minutes, which means I'm dividing into 3 segments. The first 30 minutes where each of the speaker will get roughly 7 minutes to present their perspective. And then next 30 minutes, I will have some key questions to ask to them connecting with the theme of the discussion. And the last 30 minutes will be for the audience to ask their questions. So this is the format. Um, and the wonderful thing is that we have very diverse people in this panel. So हर्षवर्धन जी आते हैं मीडिया से, एंड वेयर इन डे टू डे लाइफ ही सीज कि कैसे लॉ के प्रैक्टिस हो रहे हैं और लोगों का पर्सपेक्टिव क्या होता है कॉन्स्टिट्यूशन और फ्रेमवर्क के बारे में। हेमंत बत्रा जी हैं जो कि कॉर्पोरेट लॉ को प्रैक्टिस किए हैं लीगल फर्म्स के साथ। सो उनको प्रैक्टिस का अनुभव है कि लॉ के डिज़ाइन में क्या अच्छा बुरा कैसे होता है, कैसे लिखा हुआ है, उसको कैसे इम्प्लीमेंट प्रैक्टिस करते हैं, उसके क्या कॉन्सिक्वेंसेस होते हैं। निरंजना है पीआरएस से जो कि लॉ के ड्राफ्टिंग पे काफ़ी काम करते हैं। सो लॉ का डिज़ाइन कैसे हो रहा है, उसमें पार्लियामेंट्री कंसल्टेशन प्रोसेस में क्या होता है, कैसे जाता है, उसका एक्सपीरियंस ला सकते हैं। और हमारे पास साथ आकाश हैं विधि लीगल से जो कि लीगल एनालिसिस पे उनका ज़्यादा फोकस होता है, तो ही कैन ब्रिंग द टेक्निकलिटीज इन द प्रोसेस, राइट। एंड so we should try making best of it, most of it, and that is where I'll be focused. और तो शुरू करते हैं इस पैनल डिस्कशन को, और उसके लिए मैं इसी ऑर्डर में जाता हूं जैसे हम बैठे हैं। तो मैं शुरुआत करना चाहूँगा हर्षवर्धन जी के साथ। आई विल कीप टाइम चेक, सो रफली 7 मिनट्स पे मैं इंडिकेट कर दूंगा। So 7 minutes each of you for your opening remarks on the subject. हर्षवर्धन जी।
थैंक यू अमित जी। मैं हिंदी में ही बात करूंगा और देश को जरा हिंदी में कानून समझने की भी बड़ी ज़रूरत है। देश की आधी से ज़्यादा मुश्किल यही है कि हम अपनी भाषा में कानून भी नहीं बना पाते, और जाहिर है कि जब बना नहीं पाते तो लागू कैसे करेंगे। इम्प्लीमेंटेशन तो एजेंसीज जो होती हैं वो तो कानून कैसे ज़्यादा मुश्किल हो उसके लिए काम करती है। और हालांकि हम लोग जस्ट बिफोर कमिंग इन दिस रूम वी ऑल एग्रीड दैट वी विल नॉट रिपीट द थिंग्स, लेकिन अमित भाई के वेलकम एड्रेस के बाद और नितेश के बहुत बढ़िया प्रेजेंटेशन के बाद मुझे तो नहीं समझ में आ रहा है कि रेपिटेशन होगा कैसे नहीं। लेकिन कुछ 2-3 बातें हैं जो मुझे लगता है कि आप लोग चूंकि शायद इसमें से ढेर सारे लॉयर्स होंगे, अभी शुरू कर रहे होंगे कोर्स, कुछ पब्लिक पॉलिसी के होंगे, कुछ लोग और अलग अलग फील्ड्स के होंगे जिनको रिपील लॉ डे लिखा दिखा हुआ, तो लगा कि चलो बात करनी चाहिए। सबसे पहले तो लॉज होते क्यों हैं, और अभी आपने क्या कहा, जस्टिस, लिबर्टी, इक्वलिटी एंड फ्रेटर्निटी, और इसमें एथिक्स कहीं नहीं था। इस पूरे ऑर्डर में एथिक्स कहीं नहीं था। वी आर क्रिएटिंग मोर एंड मोर लॉज विदाउट एथिक्स। हमारी पूरी जो जुडिशियल सिस्टम काम कर रही है, दे आर नॉट देयर टू प्रोवाइड जस्टिस टू कॉमन सिटीजन। वो क्यों है वहां? जिससे कोर्ट्स चले, लॉयर्स का बिजनेस अच्छा चले, उसको कैसे इंटरप्रेट कर सकते हैं। क्या इसके लिए हमने कॉन्स्टिट्यूशन बनाया था और इसके लिए लॉज बनाए थे? क्योंकि जब हम एथिक्स की बात ही नहीं कर रहे हैं तो वो जस्टिस कहीं से भी ठीक होगा क्या? यानी आप जितने तरह के लॉज बनाते हैं उसको जो लोग इंटरप्रिटेशन कर रहे हैं वो डिसाइड करते हैं कि वो लॉज ठीक हैं या नहीं। यानी वो लॉ लॉयर्स के लिए बनते हैं, वो लॉ सेशन कोर्ट से लेकर सुप्रीम कोर्ट तक के लिए बनते हैं। और एक, जब हम कहते हैं ना कि हमारी पार्लियामेंट है, हमारे रिप्रेजेंटेटिव्स हैं, हम उनको चुन के भेजते हैं, बट दे आर नॉट एबल टू मेड विजिबल चेंज। क्यों नहीं होता ऐसा? क्योंकि वो कुछ करने की स्थिति में ही नहीं है। वो लॉज तो बना देते हैं लेकिन उनको इंटरप्रेट करने के लिए आकाश जी के दोस्त लोग हैं, निरंजना जी के दोस्त लोग हैं, बत्रा जी के मित्र हैं। तो जो लोग लॉज बना रहे हैं और जो लॉज इंप्लीमेंट कर रहे हैं, जिसको मैं कहता हूं ना कि हाउ इंप्लीमेंटिंग एजेंसीज आर यानी लॉ के साथ जो इम्प्लीमेंटिंग एजेंसीज हैं वो कैसे उसको क्रिएट कर रही हैं, वो जरा समझने की बात है। अब हम लोग अभी देख रहे थे, कोई बेगर्स एक्ट की बात कर रहा है, कोई पता नहीं कौन कौन से एक्ट की बात कर रहा है। लेकिन आप सोचिए जरा, इस देश में इन्फ्लेशन का हर 10 साल में बेस ईयर बदल जाता है, लेकिन लॉज का कोई लॉ ऑडिट नहीं है। सनसेट क्लॉजेस की तो बाद में हम बात करेंगे, लेकिन लॉज का कोई ऑडिट है ही नहीं आपके, मतलब इस देश में, भारत में। और हम किसी वकील को किससे बड़ा मानते हैं? वो कहता है कि हमने 1937 का एक केस वर्सेस गवर्नमेंट ऑफ इंडिया, उसको मैंने वहां बताया। क्यों भाई? इसका मतलब यह हुआ कि दुनिया इतनी आगे चली गई, लेकिन हम कहां खड़े हैं? हम उस वकील की जिसने पढ़ाई 1970 में की, जो प्रैक्टिस 1975 से कर रहा है और आज तक है, वो इसलिए क्योंकि उसके पास ढेर सारे रेफरेंसेज पड़े हुए हैं। तो हम लॉज नहीं बना रहे हैं, लॉज ऑफ रेफरेंसेज बना रहे हैं। यानी लॉ का ऑडिट नहीं है, जो बनाते हैं और जो इंप्लीमेंट करते हैं उनके बीच में कोई कोऑर्डिनेशन नहीं है, और हम दूसरे रेफरेंस पर लॉ को लेकर आ रहे हैं। हम मैनुअल से डिजिटल एरा में चले आए। हमारे प्राइम मिनिस्टर कहते हैं करीब 1,500 2,000 जितने भी हों, कोई क्लैरिटी नहीं है। अभी अमित जी भी कह रहे थे कि कोई क्लियर नहीं। आप में से भी कोई होगा तो करेक्ट कीजिएगा। लेकिन किसी को नहीं पता है कितने इस देश में लॉज हैं, कितने इस देश में रिपील हो गए, कितने प्रधानमंत्री जी ने ठीक कर दिए। लेकिन जरा सोचिए आप कि डिजिटल एरा में आने के बावजूद आज तक किसी एक डिपार्टमेंट के लॉ की ट्रांसपेरेंसी नहीं। तो लॉ बनाने वाले कौन है, लॉ इंप्लीमेंट करने वाले कौन है? लॉज का ऑडिट नहीं है। लॉ आपकी लाइफ बेटर करने के लिए नहीं बन रहे हैं, लॉयर्स की घर चलाने के लिए और कोर्ट चलाने के लिए बन रहे हैं। और उसके बाद क्या है? देयर इज नो सच ट्रांसपेरेंसी। लॉ मेकिंग में नहीं है, वो तो एक चीज है, लॉ इंप्लीमेंटेशन में भी नहीं है। आप कहते हैं कितने लॉ होंगे, तो हमारी एक भारत सरकार में 150 से ज्यादा डिपार्टमेंट, 10% मिनिस्ट्री हो सकती है, 150 से ज्यादा डिपार्टमेंट है। राज्य सरकार 10% मिनिस्ट्री हो सकती है, उनके भी इसी तरह से डिपार्टमेंट। हर डिपार्टमेंट के कितने वर्टिकल? लगभग देश में करीब करीब 25,000 ऐसी इंप्लीमेंटिंग एजेंसीज काम करती हैं। अब ये आंकड़ा जब आप देखेंगे तो आपको समझ में आएगा। और कमाल की बात यह है कि कोई आज तक कोई ऐसी नहीं स्टडी हुई है। और मैं जब यहाँ के लिए आने वाला था तो मैंने कहा थोड़ा मैं पढ़ लिख लेता हूं, क्योंकि वैसे भी अंग्रेजी में तो आप कुछ भी बोलें तो वो बहुत बढ़िया लगता है। हिंदी में कितनी भी अच्छी बात बोलें वो लगता है कि अरे यार ये तो हमारे जैसा बोल रहा है, तो कहां से पढ़ा लिखा आदमी होगा। कोई भी एक आज तक कोई ऐसी स्टडी नहीं हुई जो ये बता सके कि इस देश में कितने लॉज एक ही राज्य में रिपीटेटिव चल रहे हैं। आप देश के अलग अलग राज्यों में छोड़ दीजिए। और मैं चैलेंज कर रहा हूं अमित जी, मैं बड़ा खोज के आया हूं, आप लोग भी नोट कीजिए। और अगर आपको किसी को मिलेगा तो अगली बार फिर मैं मिलूंगा तो मुझे बताइएगा, नहीं तो सीसीएस को बताइएगा। अब आप सोचिए, अगर ये तक हम नहीं कर पाए हैं इस डिजिटल एरा में आके, जहां देश का प्रधानमंत्री हर भाषण में कहता है कि जैम ट्रिनिटी ने हमारे देश की लाइफ बदल दी, जनधन, आधार, मोबाइल। और अभी कल बड़ा अच्छा कैबिनेट डिसीजन हुआ कि पैन 2.0 हो जाएगा, तो उससे क्यूआर कोड से स्कैन कर लेंगे। उसमें लिखा हुआ है, मुझे बड़ा अच्छा लगा, वो लिखा हुआ है कि एक ही जगह सब कुछ पता चले। उसमें एक शब्द है ट्रूथ, जो कल अश्विनी वैष्णव ने प्रेस कॉन्फ्रेंस की। अब सवाल यह है कि उस ट्रूथ को खोजने के लिए इनकम टैक्स डिपार्टमेंट 5 साल पुराना रेट्रोस्पेक्टिव लॉ लगा के पेनल्टी लगा देता है। भाई 5 साल तक ट्रूथ कहां गायब हो गया था, वो सच कहां था? इसका मतलब यह हुआ कि लॉ तो था, लॉ इंप्लीमेंटिंग एजेंसी को जिस दिन लगा कि अच्छा आज हमें इस बिजनेसमैन को पकड़, उस दिन हमने उसको इंप्लीमेंट कर दिया। और मैं नहीं जानता हूं कि ये आज 10 साल पूरे हो गए, बहुत बहुत शुभकामनाएं सीसीएस को। लेकिन मैं नहीं समझता हूं, मैं जानता नहीं हूं कि क्या इस पर भी कोई बात हो रही है क्या? ये जो रेट्रोस्पेक्टिव इफेक्ट से ढेर सारे लॉज को पेनल्टी में कन्वर्ट कर दिया जाता है, उस पर भी कोई बात होती है क्या? क्योंकि अगर आप इस पर नहीं बात कर रहे हैं तो फिर आप कॉर्पोरेट के लिए तो हिमायती हो सकते हैं, कुछ सनसेट क्लॉज लगा दो, भाई वो पैसे वाले हैं, वो कर देंगे। वो बेचारा जो छोटा सा जिसका 25,000 रुपए का इनकम टैक्स का मसला था, वो 3 साल बाद ला के उसने कर दिया। टाइम हो गया, 7 मिनट से ज्यादा हो गया। चलिए मैं इसको बस 5 पॉइंट में समराइज करता हूं, और इस पे आप लोग भी जरा सोचिए। जो एजेंसीज हैं, क्या हमारे रिप्रेजेंटेटिव के साथ उनका कोई तालमेल है? लॉ का कोई ऑडिट हो रहा है? लॉ रेपुटेशन है तो उसका जिम्मेदार कौन है? क्या ये लॉ जो बने हुए हैं लॉयर्स और कोर्ट्स के लिए हैं, कॉमन सिटीजन के लिए नहीं है? और जो सबसे बड़ी बात यह है कि हमारा वास्ता तो कभी लॉ से पड़ता नहीं है, हम तो सिर्फ साइन करके चले आते हैं। क्या हम लॉज के बारे में कुछ सोच रहे हैं क्या कॉमन सिटीजन के तौर पर? थैंक यू।
थैंक यू वेरी मच हर्षवर्धन जी। और मेरे ख्याल से शुरुआत में ही काफ़ी थॉट प्रोवोकिंग आइडियाज़ दे दिए आपने। और ये जितने भी आइडियाज़ आ रहे हैं, मैं ये भी रिक्वेस्ट करूँगा हमारे ऑडियंस में जितने भी लोग बैठे हैं, अगर आप चाहें तो इसे सोशल मीडिया पे पोस्ट भी कर सकते हैं, और आई एम श्योर कि बहुत लोग कर रहे होंगे। उसमें रिक्वेस्ट ये होगा कि अगर हैशटैग अपील फॉर रिपील अगर ऐसे टैग करें तो सीसे से भी हम उसे ट्रैक करके शेयर रीशेयर कर सकते हैं। सो दिस इज माय हम्बल रिक्वेस्ट, प्लीज मेक सोशल मीडिया पोस्ट यूजिंग हैशटैग अपील फॉर रिपील। यहाँ पे भी कहीं पे अपील फॉर रिपील हैशटैग डे भी उसमें ऐड कर लीजिए। दिस इज द हैशटैग वी आर यूजिंग। थैंक यू वेरी मच। एंड नाउ लेट मी वेरी क्विकली जंप टू हेमंत। आपके पास माइक वहां पे है। यस, थैंक यू।
Good evening, friends. Let me give you a backdrop in the beginning. Obviously, we're going to come to you in second and third round where we can have Q&A. I would try my level best to speak closest to Hindi, which is Hinglish. So, but no guarantees, and so it's a disclaimer right in the beginning. Uh, any civilized society you talk about, life and law run side by side. You cannot live without law. Or if I was to put it the other way, you cannot live without getting affected or impacted by law. In fact, I can take even a leap to say that you cannot even die without law. Why I say this is because you have testamentary laws, non-testamentary laws, succession laws. They would go beyond your graveyard. So law definitely is integral part of our life. And any society's ethical values, their aspirations, attitudes, where are they reflected? They are reflected in their laws and legal systems. So, talking in the reverse, I have given a definition to law because law does not have any universally acceptable definition in any part of the world. People would say it's a statute or it's a diktat for governance. I would say it's a recipe which has 3 ingredients. Number 1, aspirations of the society or the constituents of the society. And you can use as many synonyms when I say aspirations: expectations, wants, desires, demands, so on and so forth. Second is logic. And third is philosophy. You can't have a law simply to address the need of the society. That perhaps was there when we had monarchs. But today you have to stitch it up well, like a fabric, with logic and philosophy. Why do you think every statute carries right at the threshold statement of objects and reasons? Because That's fundamental. That's the origin of any law. That why did it come into being? What were the objects? What were the reasons? They did not bring law, the law framers, out of the blue. You know, one parliamentarian, or let's say head of the nation, thought one night that tomorrow I should introduce that law. No, it's not like that. It is addressed to fulfill the need of the time. What does that imply? What does that imply? It implies that the law is lubricated by the timing. What happens when the aspirations change? I ask any one of you. What happens when the aspiration of the society changes? What happens to the law which is there in existence? Can anybody answer? What happens when the society's aspirations change? What happens to the existing law? Exactly. Absolutely. When the aspirations change, there is need for newer laws. There is an upheaval, there is an imbalance. Why? Because the earlier laws or the current laws become incompatible, partly or wholly, as the case may be. But they become incompatible. They, in certain situations, circumstances, they become obsolete and redundant as well. But they keep on piling up, as Harshji had mentioned. You know, there is no mechanism to see at your backyard what is piling on, because you are busy addressing the current need of the society. And when I say that the laws become obsolete and redundant, I would here like to underline that laws, as we were discussing before the event, and even Harshji also touched upon slightly, I'm sure, I mean, you're going to speak more about it, about sunset clause. You know, we have perpetual laws. You know, it's an educative thing I'm telling you. There are perpetual laws and then there are temporary laws. Perpetual laws come with indefinite life. And in India, we are fascinated and we are in love with perpetual laws. Sunset clause, I mean, I know of one law, TADA. You know, TADA was introduced in 87 and then perhaps 95 it died its natural death. But I mean, I'm sure there would be some acts, perhaps my young friends would be talking more about it. But I mean, in my experience, I have not seen very many laws which have sunset clause, which die their natural death. We have laws which are permanent laws. Now, when a society is governed by rule of law, the rule of law determines who makes laws, who administers, beg your pardon, who enforces laws, and who adjudicates laws. And believe me, we are here sitting not to debate who has the power to unmake the laws. Obviously, it is legislature. Who makes has the power, inherent, natural, to unmake. We are here debating, and not for a moment questioning the legislature or law framers for not repealing the laws. We are questioning why there is not a mechanism to review on regular basis the laws which have outlived their utility. Why they are not brought before the parliament or the state legislature, as the case may be, to repeal, again, partly or wholly, because I'm sure there are many laws which may not need to be repealed absolutely. Perhaps some sections become redundant. Well, I'll abruptly close my address because there are two more rounds. So I'll continue my discussion in the second and third round. Thank you so much. God bless.
Thank you, Hemanji, and I'm sorry while you were gearing up on many points, but my time was up, so I had to do that. Yeah. Second round, we hopefully will cover it. Yes, Niranjana, please.
Thank you very much. Let me start by thanking everyone here for showing up, and thank you, Mr. Chandra, for inviting me here. I will start by saying that I will keep this in English because I'd prefer that everyone actually hear me out and not, run right out the door. Um, so I think whatever Mr. Batra said gave me a great segue. You very timely ended on legislatures, and that is going to be the focus of what I'll be speaking today. Uh, when I was told that we would be speaking about the need to repeal bills and institutionalizing the process of it, one thing that struck me was that, repealing bills is simply one piece in a larger puzzle, right? And the larger puzzle can be law reforms. Some people call it revising laws. Thinking about what needs to change in different laws. Now there are two ways of doing this. Batraji very nicely for me elaborated. All right. Great. Yes. So Hemant really touched upon this. The first way to do this is by repealing obsolete laws. You find that if there is a need felt that a law has become unnecessary, you chuck it out. The second way of doing this is perhaps to make sure that there is a process in place whereby uh, laws are reviewed at every stage of the way. Um, let's start, if you think about how a law is made in this country, we start with the drafting process, and we can have pre-legislative consulting, which unfortunately doesn't happen far too much these days. Is there a way in which we can bring in some amount of checking for things like how long should this law be in place, adding a sunset clause, etc., in the pre-legislative consultative process. Uh, Later, when the bill is finally in parliament or state legislatures, is there a way we can discuss it for longer, make sure that all perspectives are held? Can it be sent to committees, say for instance, where we can have more stakeholder meetings, make sure that there are inputs gathered from different people, which can also help in addressing issues that may show up in the law, either in the short term, medium, or the long term. And finally, once the law has been enacted, are there processes that can be put in place, say for instance by discussing things like rules and regulations and government orders that are notified based on the law? Are there ways in which we can discuss those further to ensure that if there is some scope for obsolescence, we address that early on and nip it right in the bud? So bottom line, what I'd like to say is that there is a need to look at, to constantly keep reviewing laws, the nature, the intent of the law especially, and even the form of it. If I can give you a quick example, there is a bill pending in parliament right now. It might be taken up in this session of parliament. It's called the Boilers Bill, right? So what the bill does is it replaces the Boilers Act of 1923. Now, boiler is nothing but like, these industrial machines that are used to create steam and for various industrial users. Now, the act, remember the original act is from 1923, when there was a need for such an act because, at that time boilers could do things like blow up in people's faces and, kill them. 100 years on, a lot of things have changed. Our economy has changed, technology has improved, even our geographical boundaries have changed. Right? In 1923, the bill was passed for the British Empire in India. But now we're a completely different place. Myanmar is no longer part of us. We don't have to care about West or East Pakistan. This raises a slew of questions, right? Remember, the bill that has been introduced now retains a lot of the provisions of the 1923 Act. So it's essentially replacing the 23 Act, but it retains a lot of the provisions. So here are some questions that we could consider. Is there even a need for a bill such as this? you know, what are we trying to do? Are we going to suddenly bring in a law for boilers, another for turbines, you know, another for every single type of industrial machinery out there? What are you trying to do with this law? Is the broader idea to address something like safety in, you know, in an industrial setting? If that is the case, then a lot of other laws have already addressed this, like the Occupational Health and Safety Codes, the Factories Act has provisions, the Mines Act, all of these acts actually have provisions that do the same thing. So then is there a need to retain the law, right? Finally, there is a specific provision. I was talking to a colleague who's working on the bill at the moment, and he was telling me that there's a certain provision that was carried on from the older bill to the newer, from the older act to the newer one, which essentially gives the state the power to exempt certain areas from provisions of the law, right? And like I said before, this was simply because Myanmar and Pakistan back in the day had different requirements and might have to be treated differently, but that's no longer the case. So should we still retain these provisions? So what I'm trying to get at is, you know, I think that there is a need for the nature, form, and intent of laws to be questioned every step of the way. There are different ways to do this. We can talk about that in upcoming rounds. But finally, I'd like to end by bringing up states and state legislatures. uh, I could maybe give Nitesh a status update on repeal laws in states. I saw that a lot of his figures were from like were till 2019. So what we've been doing since 2020 as an organization is publish an annual report titled The Annual Review of State Laws, where we, again, like Mr. Harshvardhan ji has said, we look at every single bill passed in states in that year and we analyze them. What I can tell you is that every year since 2020, states have on around 2 to 3% of bills passed by states have been repeal bills, right? In some years, some states have done much better, other states have not. But a lot of the states that Nitesh mentioned in his presentation today, like Maharashtra and Karnataka and Delhi as well, a lot of these states have actually been repealing a lot of their laws and doing some decent work in that respect. We really like to stress on the fact that state legislatures actually do a lot more work that affects us on a daily basis. So any progress, I think, in state legislatures is a cause for celebration for us. But I will end my remarks there and I'll wait for the next round. Thank you very much.
Thank you very kindly. Akash, let's jump in.
Yeah. Thank you so much, Amitji. I think most of the points, a lot of points have been said. So I'll just try to give some brief remarks. Firstly, congratulations to CCS for this successful journey of 10 years. And as Vidhi also, we have been fortunate to be a part of this process. And repeal is something like, just to take a step back, when I was asked to come for this panel, जो पहला question मेरे दिमाग में यही आया था कि why repeal is important. And I, sir, try to think as both as a common man and also as a lawyer. So there's a principle that we a lot of time use in law, that ignorance of law is no excuse. So that principle always jumps up in my mind whenever the discussion of repeal actually happens, because there have been so many laws in our statute book. And always this question pops up that if suppose you have committed, so at the time when you actually get to know about the law is when you have actually committed the law. And one of the examples that I think I've been seeing is something I was also discussing with the panel yesterday, was that recently when the 3 criminal laws was actually amended. So that was an act by the central parliament. Now, interestingly, all these 3 laws basically had state amendments. So a question that was asked to me like few months back was that if suppose a state has a particular amendment, because state is amending by a separate power of legislature that they have. Now, what will happen to the state amendment? Because if you see the repeal clauses of the central laws, basically they are just repealing IPC, CRPC, and evidence. But it might be that a lawyer might be able to answer this question because we deal these issues on a daily basis. But for a common man, or for example, a police officer who is actually enforcing, this becomes a very critical, because on the state statute book, that law is still there. And if suppose they have given a, like, because if suppose there's a concurrent lit subject and both the governments are making law, so you have to take a presidential assent. Agar same provision repeat ho gaya hai in a new law, this is substantially changed new, and the wordings are basically the same, then whether the state will government like state law will apply or not, it becomes a very interesting question. And it's a question which is relevant even for like a common man, but is also relevant for the people who are actually enforcing, because they are tuned to a particular way of thinking. So again, going back to this first thought that ignorance of law is no excuse. So जब भी मतलब होगा, like where someone is caught in a particular matter, then it will become a important thing. And that brings on to the first point, because it's a very interesting question that we are discussing about institutionalizing this idea of repeal. And I personally feel, and something that we have been discussing it with you also, that uh, there is no, like for example, a lot of time when the law comes into force, it's required to be in the official gazette to be enforceable. But there is no digitized statute book that we have right now. We have India Code, which is actually a very remarkable effect by the government, but also it is not an authoritative source in terms of saying that which law is there or not. A lot of time, as when CCS must also be doing this exercise for states and all, the major task of finding obsolete law is actually to find the law. So you have to understand like where are the law actually there, what are the statute books. You have to go through gadget of last 100 years to figure out if there's an amendment that has been done or not. So going forward, if you want to institutionalize this process, it becomes extremely important that all these laws are put out in public. There is a repository so that even a common man can actually understand. So like as lawyers, sometimes we use certain international search engines wherein you can see these laws are actually structured subject matter wise. So if suppose, just imagine for a common man, if suppose there's a law which actually, if there's a repository which is reflecting 7 schedule, and I click on a 7 schedule subject matter and I say, okay, fine, under this subject matter, how many laws are there? It becomes a very easier access, as Sir was mentioning, for a common man to understand what are the laws in that area, which actually relates back to the idea of ease of living and ease of doing business. Because from a law perspective, certainty is one of the key elements. And as like when I was studying law, in jurisprudence, certainty and the fact that awareness of a law was one of the key things that we were taught at the very beginning. So that's one thought, that something that we can discuss around. The second thing is that a lot of time when these laws, like for example, my area of work is a lot in the corporate law and financial regulation sector. So in corporate and financial regulation sector, because the way the markets are evolving, markets will always give you an answer. So if a particular law that you have drafted is not working well, a lot of time indicators are there. But that might not be true for law which is more on the social side. And that becomes a very, as Sir was mentioning, that the statement of object and reasons. So in the law drafting process, uh, it becomes very important when the law has been made that you don't just put out the provisions, give the philosophy of the law, so that if there's like, even if it has been picked up by the legislature, executive, or other civil societies, if they understand what is the law's purpose, then that will be an indicator to actually review the law. And that comes to the point of auditing that we were discussing, that how to audit a law. Like for example, in a lot of projects I'm involved in, we actually assist government in drafting, helping out with the laws. And a lot of time with an experience has been that whenever like someone sits at the government level to draft a law, their perception is, okay, fine, we'll make such a perfect law that will be there for 100 years. And that is the objective. To ask someone at that stage to figure out whether the law will have a 10-year journey or a 20-year journey is an extremely difficult exercise to do. And that can only be done if we have a more data-driven approach, not just on the fact that we are doing the economic laws, but they can be certain indicators. So as the Nitesh's presentation was showing, they have a benchmark for grading laws. This is a good step if it can be institutionalized at a more lawmaking process, wherein you start grading these laws over the period of time. And now, so like this is a like a broader thought, and something more specific can be done by legislative innovation. So we'll be discussing more about sunset clauses and others. With respect to sunset clauses, I particularly feel it's a very interesting idea to have. But so the idea of a temporary law is not something which is not new to India. There were concepts of temporary law in fiscal and other taxation statutes. But the idea of sunset clauses always, a lot of time, comes with a caution that at the time when the law is supposed to be repealed, like automatically. So the call that you take today, so if you ask different departments to come up with a sunset clause, they realize it's okay, fine, 50 years. So if you say one law is saying 50 years, agla 50, agla 50, agla 50, it will be just 50 year continuously. So I personally feel that there is of course a requirement of a sunset clause, my personal opinion, but we also have to come up with the idea of reviewing legislations in the law itself. So if there's a provision which says that a law needs to be reviewed, if not today, some parliamentary procedures might evolve in future to review law. And what my experiences have been that if there's been a documented review that the law is not actually achieving its purpose, that will be a great nudge for any government to come up and repealing the law. So before we have that institutionalization of sunset clauses, I personally feel that there should be a process of auditing. I think I'll just complete myself here. Thank you.
Thank you so much, Akash, and all my co-panelists for sticking to time. I'm sorry I have to do this dirty job of, giving these indicators which might abrupt your thought process. But now I'll jump to the second segment of this discussion, where I have identified questions from what you were talking, और एक दूसरे से relate करके भी. और यहाँ पे भी मेरा रिक्वेस्ट होगा, जितना शॉर्ट रखेंगे उतना ज़्यादा फिर हम डिस्कशन डिबेट कर पाएंगे, लेंदी होगा तो फिर हमारे पास समय कम रहेगा. और मैं पहला प्रश्न चाहूँगा हर्षवर्धन जी से को पूछने के लिए, विच एक्चुअली कम्स फ्रॉम व्हाट आकाश मेंशन्ड. और आकाश ने बताया, बहुत इंटरेस्टिंग बातें की, बट उसमें से एक खास बात जो निकल के आई कि बहुत टाइम तो लॉज आपको पब्लिक प्लेटफॉर्म पे होते ही नहीं है. सो दिस इज वन सिंपल क्वेश्चन बी आस्क्ड, डू वी नो कि हमारे देश में टोटल नंबर ऑफ लॉज क्या है जो हमारे सिटीजन्स को अप्लाई को अफेक्ट करते हैं, जो कि हमें पता होना चाहिए. एंड आई कुडंट फाइंड एन आंसर. और उस समय विवेक देबरॉय जी, जिनका भी देहांत हो गया, वो इस पे रिपीलिंग ऑफ लॉ और रिव्यू पे काफी काम कर रहे थे. आई आस्क्ड दिस क्वेश्चन टू हिम एज वेल, एंड हिज आंसर वाज आल्सो दैट वी डोंट नो, राइट. तो ऐसे में लॉ बनाना, लॉ को सीक्रेसी रखना, लॉ का इम्प्लीकेशन का और निटिग्रिटी का कुछ करना, तो जब गैप होगा, एम्बिग्विटी होगा, लेस ट्रांसपेरेंसी होगा, तभी तो जो आपने पॉइंट किया कि लॉ फिर बनते ही नहीं है सिटीजन्स को जस्टिस देने के लिए, वो बने ही हैं कोर्ट्स के लिए, लॉयर्स के लिए, ताकि वही लोग जाने जो उसका यूज, अब्यूज, मिसयूज या कैसे क्या करना है वही. सो दे शुड बी द प्लेयर एंड दे शुड नो. अब आपने जो हाईलाइट किया इज अ प्रॉब्लम. तो मेरा प्रश्न आपसे ही यही है कि अगर आपने इसको सोचा है, इतना डीपली सोचा है, एंड यू हैव आइडेंटिफाइड एज अ प्रॉब्लम, इसका क्या सोल्यूशन आप देखते हैं कि इस चंगुल से, इस सर्कल से निकलना है तो कैसे निकले?
देखिए, एक तो देश जिस तेजी में आगे बढ़ रहा है, 4.5 से 5 लाख केसेज वो पेंडिंग है, और वो कोई मेरिट बेसिस पे पेंडिंग नहीं है. वो कोई इस वजह से भी पेंडिंग नहीं है कि जजेस कम हैं या कोई उनकी. और अच्छा, मैं ये भी नहीं मानता हूँ कि वो हार्ड वर्क नहीं करते. जज बहुत हार्ड वर्क करते हैं, और अगर आप लोग कुछ जजेस के साथ जो रहते हैं वो जानते हैं कि एक केस पर डिसीजन देने के लिए कितने रेफरेंसेज कितनी चाहिए, क्योंकि उनकी मुश्किल ज्यादा है. अब ये प्रेशर गवर्नमेंट पर है. आईपीसी से जब हम बीएनएस में आए तो 511 से 385 लॉज तक आ गए सेक्शंस के लिहाज से. अब ये हमारे रोज वाला मसला है. कुछ कॉरपोरेट के अलग होंगे, दूसरे अलग होंगे, लेकिन मैं आपको दो सिर्फ छोटे छोटे वाकये बताता हूँ. एक तो इंडियन एक्सप्रेस की बड़ी जबरदस्त स्टोरी थी कि ट्रक में एक आदमी सिर्फ लिफ्ट ले लेता है, और ट्रक कुछ इलीगल उसमें पोजीशन था, कुछ चीजें थी, ड्राइवर उसके साथ जो था वो पकड़ा गया, और अंत में उसके ऊपर जो लॉज लगे उसमें इलीगली वो कहीं से कहीं जा रहा है वो उस पर लागू हुआ, मोटर व्हीकल एक्ट लागू हुआ, जो ड्रग्स का था वो लागू हुआ. अब वो आदमी जिसके पास पैसे देकर कहीं एक जगह से दूसरी जगह जाने तक की रकम नहीं थी, 20 साल वो जेल में रहता है. ये इंडियन एक्सप्रेस की स्पेशल स्टोरी थी, संडे स्पेशल में उसका जिक्र जरूरी है. दूसरा एक जिसकी बात मैं भी कर रहा था कि मेरी समझ में नहीं आता कि कुछ लॉज ऐसे क्यों बनते हैं. जैसे कहते हैं कि आप गेजेटेड ऑफिसर से टेस्ट कराइए, पीएम ने कह दिया हट गया, तो अभी कहते हैं आप सेल्फ अटेस्ट कर दीजिए. मैंने कहीं सबमिट किया कोई पेपर, मैं ही दे रहा हूं, मेरा नाम लिखा हुआ है, मेरे पिता का नाम लिखा हुआ है, मैंने जो डॉक्यूमेंट प्रोवाइड किया है वो लिखा हुआ है, उस पे सेल्फ अटेस्ट करने का क्या मतलब हुआ? आज तक मैंने बहुत से लोगों से, बड़े बड़े विद्वानों से पूछा, यहाँ भी 3 विद्वान हैं, कुछ तो बताएंगे, लेकिन कोई उसका सही से, वो कहते हैं हाँ ठीक है आपने लिखा है इसलिए आपने ओन कर लिया। वो ठीक ऐसे ही है जैसे कोई म्यूचुअल फंड या पॉलिसी ले रहे हैं तो उसमें छोटे छोटे में लिखा होता है, उसमें कहते हैं ये क्लिक कर दीजिए नहीं तो आगे ही नहीं बढ़ेगा। ठीक वैसे ही है जो आपने सवाल पूछा ना, जो एम्बिग्विटी है, एक्चुअली कोई भी नहीं चाहता कि आपके डिपार्टमेंट के लॉज पता चले। लॉज में सीक्रेसी क्यों होनी चाहिए? आपने भी एक शब्द इस्तेमाल किया, सीक्रेसी भी होनी चाहिए। क्यों होनी चाहिए? इसीलिए होनी चाहिए क्योंकि एथिक्स नहीं है, इसीलिए होनी चाहिए क्योंकि वो सिर्फ लॉयर को पता होगा, वो कॉर्पोरेट लॉ के प्रैक्टिशनर को पता होगा, वो इनकम टैक्स लॉ के प्रैक्टिशनर को पता होगा। अब मैं अपना एक वाक्य बताता हूं। हम एक चैनल में थे, उसका नाम भी बताते हैं, P7 न्यूज चैनल था। इस देश की बड़ी फ्रॉड के आरोप वाली चिट फंड कंपनियों में से एक पल्स ग्रुप उसके मालिक थे, और मैं उस चैनल में था, बिजनेस एडिटर के तौर पर था। एक दिन पता चला कि चैनल बंद हो रहा है। अब वो ठीक है, तो मैं गया, मैं लड़ा, मैं धरना दिया, फिर लोग भी हमारे साथ है, वरना सब मान के चले गए थे ठीक है पैसे मिल जाए, खैर वो सब अलग बात है। लेकिन हम फिर असिस्टेंट लेबर कमिश्नर की कोर्ट में हमने केस दाखिल कर दिया सेक्शन 4 के तहत। उस दिन के पहले हमको भी वो सेक्शन 4 नहीं पता था। इतनी पतली सी बुक आती है, बहुत पतली सी, इतनी पतली सी बुक आती है, हर कोई अपने अधिकारों के लिए जो कहीं नौकरी कर रहा है वो काम कर सकता है। उसमें हमने क्या नोटिस लगवाया, बिना हमारा भुगतान किए हुए ये कंपनी बंद नहीं हो सकती। एक लाइन की बात थी। असिस्टेंट लेबर कमिश्नर हमारे इलाहाबाद यूनिवर्सिटी के सीनियर थे, तो उन्होंने कहा कि आप वकील लेंगे क्या? तो हमने कहा यहाँ कौन सा वकील होगा? तो पता चला जो असिस्टेंट लेबर कमिश्नर रिटायर हो जाते हैं वो वहां वकील हो जाते हैं। अब आपको अगर लॉस समझना है तो मैं बड़ा, इसलिए मैंने कहा, ये मैं सोच के आया था कि ये बताऊंगा, अच्छा हुआ दूसरे राउंड में आपने वही सवाल पूछ लिया। हमने वो बुक पढ़ी, हमने हर बार जिरह की, कंपनी की तरफ से 2 बड़े लॉयर आते थे और अंत में वो पिट के चले गए, और हमने बाकायदा 350 लोगों को 3 महीने की नोटिस पीरियड की सैलरी दिलाई। उसके बाद वो फुर्सत हुई, सब काम वो हमने कराया। क्यों? क्योंकि हमने थोड़ा सा पढ़ाई की। और मैं क्यों कहता हूं कि लॉ सबको पता होना चाहिए उसकी भाषा में, क्योंकि उसमें जो ऑपरेटिव पार्ट होता है वो होता है एक पैराग्राफ, और जो डिसीजन होता है वो होता है 1400 पन्ने का। भाई साहब 1400 पन्ने होते क्या हैं? 1400 पेजेस। अभी हम एक दिन पूछा हमने कि भाई कोर्ट ये ऑर्डर रिजर्व क्यों रखती है? अब आप लोग सब आज से सब ध्यान दीजिएगा जो मैं बता रहा हूं। कोर्ट कहेगी सेंसिटिव इशू है इसलिए ऑर्डर रिजर्व। मार्च में भाई साहब ने फैसला ले लिया था जज साहब ने, सुनाएंगे कब? जुलाई में या नवंबर में। क्यों भाई? तो पता चला नहीं, बहुत सेंसिटिव इशू है। तो सेंसिटिव इशू है तो क्या है? अब मैंने एक बार पूछा, तो हमारे एक जो कोर्ट को कवर करने वाला रिपोर्टर था, उसने, अभी है 1.5 मिनट मैंने देख लिया है, तो उसने बताया कि भाई ये मसला होता है, जितने लोग हैं उन सबसे बात होती है, कहीं सरकार का मसला है वो सब समझ ले। तो हमने कहा यार वो सब तो चलो ठीक है, लेकिन जिसमें कोई सेंसिटिविटी नहीं होती, नॉर्मल मैटर होता, उसमें भी क्यों ये रिजर्व कर लेते हैं? यानी आपको लॉज पे जो जस्टिस देना है उसमें भी रिजर्व कर लिया, तो आपने जो जस्टिस डिलेड, जस्टिस डिनाइड है वो भी तो लागू हुआ ना भाई। 4.5 लाख केस जो पेंडिंग है, आपके लॉज में पता नहीं है कि क्या है, और उसके बाद आप डिसीजन भी दे रहे हो तो वो भी आपको पता नहीं कि कब आपको देना है। तो और वो भी, तो ये जो आप कह रहे हैं कि इसका सॉल्यूशन क्या है, तो सबसे पहले तो ये किसी भी इंस्टीट्यूशन के फॉर्मेशन के साथ तय हो कि आपकी कंपनी की क्या क्या पॉलिसी है। ये मैं कंपनी के संदर्भ में कह रहा हूं, ऐसे ही सारे लॉज के संदर्भ में हो गया। जैसे उदाहरण के लिए, अब थोड़ा सा और पॉलिटिकल में कर देता हूं क्योंकि जर्नलिस्ट हूं, ये लोग कॉन्स्टिट्यूशन अपना सही से बनाए नहीं तो शरद पवार की पार्टी भतीजा लेके भाग गया, क्योंकि इलेक्शन कमीशन सरकार कौन था? उद्धव की पार्टी एकनाथ शिंदे लेके भाग गए, क्योंकि उसमें साफ साफ लिखा था नंबर ऑफ लेजिस्लेटर्स, नंबर ऑफ पार्लियामेंटेरियंस, नंबर ऑफ डिस्ट्रिक्ट प्रेसिडेंट, नंबर ऑफ, और उसके बाद क्या था कि कॉन्स्टिट्यूशन में आपने क्या मेंशन किया है। यानी जब आप लॉज को क्लैरिटी के साथ, अभी आपको लॉ नहीं है, वो उनका अपना कॉन्स्टिट्यूशन सिर्फ समझाने के लिए बता रहा, वो लॉ नहीं है, लेकिन किसी भी डिपार्टमेंट से रिलेटेड, किसी भी स्टेट से रिलेटेड या भारत सरकार से रिलेटेड जितने तरह के लॉज हैं वो क्लियर नहीं है। क्लियर क्यों नहीं करते? एथिक्स नहीं, बेईमानी करते हैं। बेईमानी के लिए लॉज में इतने लूप होल्स रखते हैं, इसीलिए किसी एक मसले में किसी एक आदमी को जमानत तुरंत मिल जाती है, किसी एक आदमी को 10 साल तक उसी मामले में अंदर रहना पड़ता है और जमानत नहीं मिलती है। उसके बाद फिर थोड़ा सा पीआरएस को एक केस स्टडी मिल जाएगी, कभी सीसीएस एक बढ़िया डायलॉग कर लेगा, उससे आगे कुछ होगा नहीं। यानी ट्रांसपेरेंसी चाहिए, एथिकल लॉज चाहिए, हमें क्यों दूसरा कोई इंटरप्रेटर चाहिए। और आज के समय में जब आपको टेक्नोलॉजी सब कुछ दे दे रही है, मतलब मैं जितनी बातें बोल रहा हूं, अगर मैं यही अपना मोबाइल ऑन कर दूं तो जिस भाषा में चाहूं वो मैं अभी अगले 30 सेकंड में आपको पढ़ के सुना दूंगी। सिर्फ इसको मुझे वही सिर्फ नोटबुक ही सिर्फ ऑन कर देना पड़ेगा, इसके अलावा कुछ नहीं करना पड़ेगा। सवाल यह है कि इसके बावजूद क्यों आज तक देश में लोगों को पारदर्शिता के साथ उनकी भाषा में कानून क्यों नहीं पता? समाधान एक लाइन का है, एथिक्स, ट्रांसपेरेंसी।
Thank you very much, sir. Now I will jump to Hemant Batra ji. Sir, आपने बोला there are 3 guiding key factors जब एक लॉ बनता है तो, और उसमें मैंने थोड़ा ऑर्डर अपने हिसाब से चेंज कर दिया। फर्स्ट है कि एस्पिरेशन, जो आपने बोला कि एस्पिरेशन उस समाज का क्या है, और उसके लिए फिलॉसफी और फिलोसफिकल आर्ग्यूमेंट्स क्या हैं। तो इज़ देयर दैट बेस, और वो अगर बेस अवेलेबल है फिर हम एक डॉक्यूमेंट तैयार करने की कोशिश करते हैं, और उसमें जो प्रोविजन होते हैं वो बेसिकली आप देखेंगे देयर इज सम काइंड ऑफ रैशनैलिटी, ऑब्जेक्टिविटी। सो एनीवे, सो द फाउंडेशन वो डिपेंड करता है फिलॉसफी और फिलोसफिकल क्लाइमेट ऑफ द टाइम एंड एस्पिरेशन ऑफ द सोसाइटी। बट डिज़ाइन पार्ट में रैशनैलिटी आती है, और अगर ऐसा है तो फिर कोई भी ऑब्जेक्टिव को रख के हम लॉ बनाते हैं, और खासकर जो आम जनता से जुड़े होते हैं, तो उसमें कभी ऐसा क्यों नहीं सोचा गया, या शायद सोचा गया, हमें पता नहीं है, कि भाई देयर इज अ सेट टाइमलाइन कि 5 साल में, 10 साल में, 20 साल में इधर हम अचीव कर लेंगे या इसके ऑब्जेक्टिव एक्सपायर हो जाएगी। और हो सकता है हमें नहीं भी पता कि 10 साल में, 20 साल में होगा कि नहीं, बट एटलीस्ट रिव्यू हम करेंगे। और इसको हो सकता है सिर्फ इसलिए नहीं कि रिपील करना है, हो सकता है इसको फर्दर स्ट्रेंथन करना है, फर्दर अपग्रेड करना है। तो इन डिजाइन में जो रैशनैलिटी रहती है टू इम्प्लीमेंट एनफोर्स, बट द गाइडिंग थिंग इज दैट वी हैव टू अचीव अ सेट ऑफ ऑब्जेक्टिव्स, तो वो रिफ्लेक्ट क्यों नहीं होती है? क्या करें कि हो सकता है, या इसके बैकग्राउंड में ऑलरेडी काम हो चुका है जो शायद हमें पता नहीं है। यू हैव अ माइक।
I think ये it's more to do with mindset, because as you know India is labeled as over legislated and under governed. हमारे यहाँ जो लॉ मेकर्स हैं वो ये सोचते हैं कि anything under the sky, if it has to be dealt with, you need a law for that. You know, you feel that, you know, if we need people to comply with any contingency or any conditions, or for that matter any diktat, you need a law for that purpose. तो पहला तो ये माइंडसेट है, और नंबर 2 क्या है कि हमारे पास लॉ कमीशन है, जो मेरे हिसाब से 22 लॉ कमीशंस चल चुके हैं, 23वां शायद अभी बनने वाला है, 22 have been in place, and nearly 200 reports उन्होंने टेंडर की हैं. I think CCS should do research on those reports as to how many of those recommendations which were contained in these reports were actually sort of acted upon by the government, if those sort of studies have still not been done. Because I know for sure that law commission की references यही हैं कि reforms, repeal, and plus overall governance में जो भी legislation involved हैं उसको कैसे improve किया जा सकता है. Now, despite the presence of लॉ कमीशन 1998 में पीसी जैन कमीशन या कमेटी कॉन्स्टिट्यूट हुई उसके बाद 2014 में रामानुजम कमेटी या कमीशन को कॉन्स्टिट्यूट किया गया टू आइडेंटिफाई फर्स्ट ऑफ ऑल द लॉज दैट कितने लॉज हैं और रामानुजम कमीशन जो 2014 में बना उन्होंने बोला कि 1834 से लेकर 1949 तक 380 लॉज ऐसे हैं जो अभी भी वर ऑन द बुक्स ऑफ द ऑन द बुक्स ऑफ द स्टैट्यूट और 1950 ऑनवर्ड्स 2401 laws existed on the face of the statutory books. So in total ये हो गए 2781 और इसमें उन्होंने बोला 1750 को खारिज किया जाए, रिवोक किया जाए, ऑब्लिटरेट, एब्रोगेट, व्हाटएवर यू मे कॉल इट, इसमें उनको कैंसिल किया जाए। तो पहले तो जैसे हरजी भी बोल रहे थे कि यही नहीं पता कि लॉज कितने हैं, उसके लिए भी हमारे को एक कमीशन बिठाना पड़ा। देयर इज नॉट, इट्स अ बेसिक थिंग, हमारे पास डेटाबेस ही नहीं था टू सी के सेंट्रल स्टैट्यूट्स कितने, स्टेट की तो बात छोड़ो। तो सो इट्स ऑल टू डू विद माइंडसेट, बट आई एम प्रीटी श्योर दैट आज जो हम ये डिबेट कर रहे हैं, ये डिबेट भी आउट ऑफ द ब्लू नहीं है, एक मूवमेंट चल पड़ी है। और यू नो आई डेफिनेटली कॉम्प्लीमेंट द करंट एस्टेब्लिशमेंट बिकॉज दे हैव टेकन सम ग्रेट इनिशिएटिव्स और उसके कारण you know everybody has started thinking that we are definitely over legislated country and there is excessive governance which can be minimized only by introducing a permanent review and repeal system. Thank you.
Thank you so much, Hemant ji. Now I'll jump to Niranjana and to take forward where actually Hemant stopped. तो उन्होंने कहा कि ऐसा रिव्यू होना चाहिए, रिपील होना चाहिए, but because working with PRS you better understand the legislative process right from conceptualization maybe to drafting to consultation to passing the bill to notification etc. आपको पूरे प्रोसेस में कहीं पे अपॉर्चुनिटी और स्कोप दिखाई देता है जहाँ पे ऐसे प्रोविजंस को इंक्लूड किया जा सके या कराया जा सके इन द एंटायर ड्राफ्टिंग टू द प्रोसेस of creating a legislation? Where do you find scope and opportunities to integrate what Hemant asked?
Thank you. So there's a lot of scope for this, and if I can take you, as I did earlier, maybe through the drafting process, and we can see at what stages what can be done. Like I said earlier, pre-legislative consulting is one option. Once the bill has come into parliament, right, what is the typical steps that take place? There is a possibility that the bill gets sent to committee, right, where it's a smaller group, you invite a lot of stakeholders. There is a lot of scope for even the public to contribute in this. I don't know if you might remember the Waqf bill is currently in committee. And the Waqf bill had been opened out for public consultation, and there were reports, across news media saying that there were 12,000, petitions that the committee received from the public. Now, that is I think that's a great thing that committees provide. That's a great option that committees provide. The ability to hold public consultations. Another example that I can give you is in a state bill in Kerala. So there was a very contentious bill called the Public Health Bill in Kerala. This was in 2021. So what it was referred to committee, as a lot of bills in Kerala are. And what the committee did is travel to different cities in Kerala and hold public consultations where anyone could go in and talk about their issues and what could be done to improve the bill. So this is one aspect when you try to bring in stakeholders, the public, anybody who might be directly affected by the provisions of the bill. Another thing that so let's just think about where we are. Committee has committee report has come back. The bill is being discussed. Now, how well is the bill being discussed in Parliament? Unfortunately, what we see today is that bills don't really get discussed for a really long time. And remember that whatever happens in committee is closed door, right? We don't really know what is happening, but everything that happens on the floor of the House is public record. So we don't really know, when bills don't get discussed for very long in Parliament, we don't really know how legislators are thinking about it, how different people are thinking about it. And they also don't get a lot of time to give in their suggestions. Now, sir, you very kindly gave us 7 minutes, in the first round. Imagine an MP goes into Parliament and has to talk about a 1400-page bill in 2 minutes, right? So it's virtually impossible to get the kind of deliberation that we want on a bill in such reduced time. States, the matter is actually a little worse. For example, in certain states, about 8 states of the country, every single bill introduced in a year gets passed on the same day that it was introduced, right? So in some states, I don't want to name states, but in some states, so there's a 5-year term of the legislature, every single bill passed by the legislature was introduced and passed on the same day, right? For 5 years. Now, I'd like to also share an anecdote. So to address some of the remarks that I think Akash made earlier and subsequently a lot of people have spoken about, there is a lack of information about the number of bills that are passed, the legislations that are in force today. What PRS has tried to do is address a bit of that gap, where we identify bills passed, we put it up on our websites, we do the trawling through gazettes and linking amendments and all of that. But we also hit roadblocks in terms of access to data. So this one time we were trying to get data from Assam, and Assam as a state doesn't really pass a lot of bills, right? So we had seen that in preceding years they passed 8, 10 bills, and then suddenly in 2022 they decided, hey, let's pass 82 bills. So we got the list of bills, and we were talking to a friend from the Vidhan Sabha, and he was really proud of himself, hey, we passed 82 bills in a year, and they had sat for a handful of sittings. And we did the computation, and we were like, wait, that's insane. Like, how can you pass 82 bills in 10, 15 days of sitting? We really had to step back and sort of try to explain that that's maybe not the healthiest process out there, but unfortunately that's what is happening. So very simply, have more sittings, discuss for longer, deliberate for longer. That's a great way to improve the quality of legislation, and that is a great way to bring in a lot of the aspects that Harshvardhanji and Hemant had mentioned. Yeah, like I mentioned earlier, another way to do it is a little bit post facto, in the sense that rules and regulations come out. Again, what we see is that these things are not really discussed in Parliament. So Parliament has something called a subordinate legislation committee, which is supposed to look at all of the rules and regulations that are brought out by the government, and examine whether it's in line with the law and so on. But unfortunately, they just get tabled, and it's just on paper. Nobody really actually comes out and talks about it. So these are some of the places where I think there is scope for change.
Perfect. Thank you very much. This is a wealth of knowledge and information. Now I'll jump to Akash. And Akash, you made a couple of very interesting points. And first that grabbed my attention is the best way one gets to know about a existence of a law जब वो law break करता है, right? तो जब आप conflict में आते हो तब पता चलता है, oh, there is a law to regulate or control or put things in order. हमारा एक छोटा सा अनुभव रहा जब हमने महाराष्ट्र और दिल्ली के स्टेट्स के रफली 23-25 लॉज को डॉक्यूमेंट किए थे, और महाराष्ट्र में जब हमने गवर्नमेंट को चीफ मिनिस्टर ऑफिस को सबमिट किया, माय ओन एक्सपीरियंस वाज इट वाज फॉरवर्डेड टू सेक्रेटरी, और उसके बाद सेक्रेटरी ने एक डेजिग्नेटेड सेक्रेटरी को किया, एंड दे कॉल्ड अस फॉर अ मीटिंग. उस मीटिंग में आई वाज सरप्राइज्ड, वो जितने लॉज थे, जितने डिपार्टमेंट से रिलेटेड थे, उन सारे सेक्रेटरीज वहाँ पे उस मीटिंग में बैठे हुए थे. दे हैव क्रिएटेड एन एक्सेल शीट जिसमें हर लॉ के ऊपर पे उनका कमेंट था, किसको वो रिपील कर रहे हैं, किसको नहीं कर रहे हैं, वो नहीं करने का भी रीज़न भी लेके वो रेडी थे. एंड फर्स्ट टाइम आई वाज सो इम्प्रेस्ड इन अ मीटिंग कि अच्छा इतने सीरियसली वो मैटर को ले रहे हैं. एंड विद इन मंथ्स एंड इन द मीटिंग इटसेल्फ दे सेड 23 में से ये 19 को हम रिपील करेंगे, ये 4 को नहीं करेंगे, इसके हमारे ये रीज़न हैं. उसमें एक दो का ये भी था कि वो बिल भी जो हमने दिया था, उन्होंने बोला कि ये बिल का आपको मिला कहाँ से, हम तो ढूंढ भी नहीं पाए. राइट. सेम प्रोसेस हमने रन किया था दिल्ली के लिए. सो दिल्ली में भी 25 लॉज को डॉक्यूमेंट करके सबमिट किया था. और यहाँ पे कुछ नहीं हुआ. कुछ नहीं हुआ मीनिंग हमारा सबमिटेड डॉक्यूमेंट भी कहीं मूव किया कि नहीं किया हमें नहीं पता. क्यों नहीं पता? जो हम दैट वाज माय लर्निंग इन द प्रोसेस. दिल्ली बीइंग अ यूनिक स्टेट वर्सेस यूनियन टेरिटरी, एक तो बहुत चीज़ों पे उन्हें क्लैरिटी नहीं थी कि वेदर स्टेट असेंबली कैन रिपील दिस पर्टिकुलर लॉ और इट विल गो टू द MHA और द यूनियन गवर्नमेंट करेंगे. बहुत से लॉज दिल्ली ने अडॉप्ट किए थे जो पहले के पंजाब के, हरियाणा के और यूपी के एक्सटेंडेड लॉज थे वगैरह वगैरह. सो इन दैट एंटायर एक्सरसाइज वन की थिंग वाज कि एक तो लॉज को पता होना, फॉर विच यू presented a very good solution. I think majority of us will agree कि एक digital platform हो जहाँ पे ये laws हो, तो available है तो फिर आगे का सोच सकते हैं. But similarly अगर laws को हाँ digital public platform पे डालना है, where do you find scope? Do you find कि कोई agency है, law commission है, कोई authorities है, where do you find scope and opportunity if this idea really has to be converted into practice? इसको reality बनाना है. Where do you find scope? Scope, opportunity, how do we move forward?
So of course there can be two things like yeah. AC.
Volunteer Snehal, could if the AC could be reduced a little bit. हाँ. वो आपको directly आ रहा है, मेरे पास आ नहीं रहा. Anyways, Akash, please continue.
So I guess like it can be, so there can be two things in terms of repository. One is the fact that, for example, we have this official gadget, and a lot of time, like I don't know how many of you have actually gone through an official gadget. Now it's an e-gadget, so you can actually see it. And the idea is that that entire notion, jo hai ki that a law should be public to be enforceable, is been implemented through that e-gadget. So as sir was saying that. A lot of time you're not aware, like there's an element of secrecy. A lot of time the secrecy element is coming because somewhere in a big gadget, there is a place where there's a provision of law that has been amended or a regulation or rule is amended. Very difficult to trace out. So there might be some institutions like which are working on the private side, some portals that lawyers actually use that actually try to codify. So they do that because just imagine that they are basically selling a law that already should be in public domain and which is already being stated. So one of the place where I personally see is that that e-gadget, there should be some form where that transformation should be done, particularly for law. So today the idea is that if anything, the government policy or something that has to be put out, that has to put out through that e-gadget portal. But there should be some place wherein there should be a special gadget for the laws that are passed by the parliament, and that is something that can be done even by the legislative department or the Ministry of Law and Justice. So, but the call, I think, something that is still a debatable thing that we'll have to take on is the fact that whether we want a government promoted search engine or an engine which, if suppose something is written on the website, that is a hard letter of law. And that is something, both of things will have its own implementational challenges. So if suppose something is not updated over there, it means that the law is not enforced. So that of course is a practical challenge that needs to be done. But some of the ideas like on that thought.
Perfect. Thank you very much.
जो भी आकाश जी ने कहा था ना, अरविंद जी को तब पता चला जब वो जेल चले गए, तब कई लॉज का पता चला. उन्होंने कहा कि नहीं नहीं ये तो फ्लैग होस्टिंग ये करेंगे, तो उन्होंने कहा नहीं नहीं ये नहीं कर सकते. तो ऐसे कई लॉज का पता तब पता चला जब वो जेल में गए. और मुझे लगता है कई बार जो आपने कहा ना कि दिल्ली गवर्नमेंट ने कुछ किया नहीं, करने की इच्छा नहीं है. पॉलिटिकली मोटिवेटेड लॉज, पॉलिटिकली मोटिवेटेड बिल्स की भी बात होनी चाहिए. और निरंजना ने बहुत सीरियस इशू की बात की. अभी वक्फ की हम बात कर रहे हैं. वक्फ की जेपीसी की जो प्रोसीडिंग्स थी उसमें क्या पता है? आप में से किसी को कुछ पता है क्या हुआ? कोई एक बताइए जरा, सीरियस नोट पे जरा कोई तो बताइए, आप लोग इतने अवेयर लोग हैं, कोई बताइए। नहीं नहीं, जेपीसी की कोई एक खबर आपको पता है, ध्यान में है किसी को? लड़ाई झगड़ा, और किसी को कुछ ध्यान में है? जेपीसी से सिर्फ एक खबर निकल कर आई कि कल्याण बनर्जी ने कोई ग्लास बॉटल या ग्लास वो उठाकर फेंक दिया और उससे कल्याण बनर्जी का अंगूठा या हाथ कुछ कट गया, ये खबर है। वो उसी लड़ाई की बात है, उसी लड़ाई की बात। आप सोचिए, जिस इशू पर देश के मतलब इतने बड़े इलाके में बार बार बड़े बड़े जलसे हो रहे हैं, रैलियां हो रही हैं, और जिसको कहा जा रहा है कि इतना बड़ा कानून है, उस पर सिर्फ ये खबर निकल कर आ रही है। अब ये भी एक बहुत सीरियस इशू है, और हम अभी इसलिए बात कर रहे हैं कि आज कॉन्स्टिट्यूशन डे तो है ही, अभी हमारी संसद भी चल रही जो नहीं चल रही है। तो कमाल ये कि जब संसद चलेगी और नहीं चलेगी तो बिल ऐसे ही पास होंगे, और उसके बाद हम कहेंगे कि 110% आउटकम हो गया, 120% हो गया, पहले 30% था। तो ये ज्यादा सीरियस इशू है। मुझे लगता है कि इस पर हम लोगों को बात करना चाहिए कि सदन जब चले तो जो इश्यूज हैं उन पर बात हो, बिल पर डिबेट हो। बिना डिबेट के बिल का पास हो जाना बहुत अच्छा नहीं, लेकिन अगर संसद चले ही नहीं तो वो दोनों पार्ट है।
थैंक यू। थैंक यू। और जैसा कि हम देख सकते हैं, वी हैव अ वेरी एक्टिव ऑडियंस, तो आई एम श्योर दे हैव लॉट ऑफ क्वेश्चंस। आई डू हैव मेनी क्वेश्चंस, लेकिन उसको मैं रिजर्व में अभी रखता हूं। एंड लेट्स ओपन द फ्लोर फॉर द ऑडियंस। सो एक एक करके आप क्वेश्चन कर सकते हैं। रेज योर हैंड्स बिफोर आस्किंग द क्वेश्चन। वी हैव वॉलंटियर्स, और मेरे ख्याल से ऑलमोस्ट हर रो पे कुछ माइक्स भी पड़े हुए हैं। माई ओनली रिक्वेस्ट विल बी ask question straight, identify the speaker जिनको आप address करना चाहते हैं, या general है जिस पे कोई भी कर सकते हैं, but make sure it's a question and it's not a commentary. That's all. Yes, sir. Mics, please.
Hi. The panel discussed about the aspiration for bringing a new law. I just want to know, like, if, there are lots of aspiration from the beneficiary groups. Like the farmers were protesting for, making a law on MSP, or some, the servants ask for OPS or similar kind of laws. So if government start, like, acting based on the aspiration of those beneficiary groups, then how many laws we will have in a democratic setup? So that is an open question. Who may wants to reply?
Perfect. Thank you.
See, when I said aspirations, I didn't mean to say directionless, reckless aspirations. Obviously, there is a system of filtration, and coupled with political compulsions as well, because this is a democracy, and democracy, whatever you may say, leads to one tagline: survival of the fittest. So there are many voices in democracy. Which one gets recognized and which one actually hits the pole in the center of the parliament is something which I need not say. Anybody who follows political science or public policy would know. But definitely laws are made based on aspirational landscape. But there are elements of compulsion, political constituency-based needs, and so on and so forth, and even election manifestos, for that matter. So it's definitely a mix of all. But I do agree with you that if aspirations of all were to be welcomed, then probably we'll see parliamentarians sitting on the statute books rather than on their seats.
Thank you. Thank you, Amit. It's been a pleasure. I mean, absolutely. हम different background से आते हैं, but ज़बरदस्त आज knowledge हमारी बड़ी. Sir, aspiration needs. I mean, from what it appears, from what we read, what we see everyday life, aspiration needs जब सिर्फ corporate houses की और नेताओं की जब उनकी needs जब priority पे है, you said review of the law क्यों नहीं उसके लिए भी तो एक लॉ बनाना है, और लॉ उन्होंने ही बनाना है जो वहाँ बैठे हुए, जो जानबूझ के आंखों पे, आई मीन हु डोंट हैव आई मीन द कैपेबिलिटी ऑफ कॉम्प्रिहेंडिंग द जनरल पब्लिक्स एस्पिरेशन नीड, उनमें जिनमें नहीं, तो कैसे वो बनाएंगे? क्वेश्चन एक्चुअली एक तो ये है, इफ दे आर सपोज टू मेक द लॉ टू रिव्यू और रिपील द लॉ, व्हाई वोंट दे पर्पसली डिले इट? बिकॉज उनको सूट बहुत सारी चीज़ें में नहीं करते हैं। हमारा प्लेसेस ऑफ वर्शिप एक्ट अभी हुआ, कितने सालों से था, सदियों से था, उनको पता था, दैट्स द जनरल पब्लिक्स एस्पिरेशन, बट वाज काइंड ऑफ पुश्ड बैक ऑन द जस्ट वन क्वेश्चन मोर। ये आई वाज द बॉम्बे प्रिवेंशन ऑफ बेगिंग एक्ट, राइट? सो जिस उसमें से निकल के आया, इसको क्यों रिपील नहीं करना चाहिए? क्योंकि जो कॉप है वो harass करेगा टू द बेगर्स। आई मीन आइडियली इन ए सेन सोसाइटी, begging as such, I mean God forbid किसी को भी वो नहीं, तो एक eyesore है, I mean it should be actually done away with, but also I mean I would want an opinion कि rehabilitation of the same people, I mean they will not be forced ever at all कि उनको भीख मांगने आना ही पड़े। अब उस पे बात फोकस आ रहा है कि जी इसको उस पे जो कॉप जो है ना वो उसके एडवांटेज उठा रहा है, तो is that looking at the problem from a very different or from a wrong angle is my question. Thank you. सब बुद्धिजीवी, हर्ष जी बताएं तो।
पहला पार्ट में बेसिकली
अपनी कन्वीनियंस के लिए
है, वो ज़्यादा बनाना चाहता है, व्हाट इंसेंटिव ही हैज कि वो रिपील करे।
नहीं, एक तो पहले वी सीरियसली नीड टू डिफरेंशिएट बिटवीन लस्ट, प्रेशर ग्रुप एंड एस्पिरेशन। सबसे पहले तो ये शुरू करेंगे ना, नहीं तो फिर एस्पिरेशनल, अगर वो एस्पिरेशन है तो हम एस्पिरेशन की बात करते हैं तो क्या होता है वो एस्पिरेशन? मतलब बच्चा निकला, उसको ग्रो करना है, उसको अब कोई बहुत बड़ा इंडस्ट्रियलिस्ट है, उसको बहुत लाखों करोड़ों के टेंडर चाहिए, तो ये तो एस्पिरेशन नहीं हुआ ना। तो थोड़ा मतलब अंग्रेजी के शब्दों का सही इस्तेमाल करें। वो जो फार्म लॉज के अगेंस्ट थे वो लस्ट ग्रुप था, प्रेशर ग्रुप था, और जैसे कहते हैं ना कि ओल्ड आर नॉट ऑलवेज गोल्ड बट चेंज इज ऑलवेज गुड, तो चेंज के अगेंस्ट थे वो, तो वो गुड नहीं थे, वो बैड थे। और हो सकता है कि इस पे अलग अलग एस्पिरेशनल, मतलब इस सरकार ने अभी, चूंकि हम 2014 से ही ये 10 साल ये पूरे हुए सरकार के भी, और 10 साल इस जो नेशनल रिपील लॉ डे की बात हम कर रहे हैं उसको जो मनाने की बात कर रहे हैं, इस सरकार ने एस्पिरेशनल डिस्ट्रिक्ट्स फाइंड आउट किए। वो कौन से थे? एस्पिरेशन किसकी होगी? जिसके पास पानी नहीं है, बिजली नहीं है, खाना नहीं है, कपड़ा नहीं है, सड़क नहीं है, जिसको हम अभी तक क्या कहते थे? बैकवर्ड डिस्ट्रिक्ट्स। वो असली एस्पिरेशनल्स है, ये समझिए। आप पहले डिफरेंशिएट करेंगे तो बड़ी आसानी से सब समझ में आने लगेगा। फिर अभी क्या हुआ? एस्पिरेशनल ब्लॉक्स, यानी डिस्ट्रिक्ट के नीचे हम ब्लॉक में गए, ये हम गवर्नमेंट के हिसाब से कह रहे हैं। अब आप सोचिए, जैसे हम कहते हैं ना, मैं अभी बद्रीनाथ जी हर साल जाता हूं, तो अभी होके आया दीपावली के बाद, तो वहां माणा हो गया भारत का पहला गांव। आप जाते हैं तो फोटो भी वहीं खिंचाते हैं। तो पहले कौन होगा? कहां से कानून बनना शुरू होगा? कानून उसके लिए होगा जो सबसे वीकर सेक्शन से आता है, जो लास्ट में खड़ा हुआ है। आप गांधी जी का चाहे कह दें, जिसको हम कहते थे ना सबसे कतार में सबसे पीछे खड़ा आदमी, बाबा साहब अम्बेडकर का वंचित शोषित, कानून की भाषा में अगर बात करें तो संविधान, दीनदयाल उपाध्याय का एकात्म मानववाद। अब इसमें दरोगा कहां से आ गया? उसका तो कोई काम है नहीं, लेकिन उसको हमने पावर दे दी लॉ को इंप्लीमेंट करने की। दिल्ली में ट्रैफिक चालान नहीं कटता है, ट्रैफिक वायलेशन हो ये पकड़ने के लिए दरोगा खड़ा रहता है। तो ये जितने भी कानून हैं, और उसमें जो, जब हम दरोगा कह रहे हैं, सिर्फ इंस्पेक्टर नहीं है, जो भी उसके एनफोर्समेंट एजेंसी का जो हेड है या जो भी वहां जाता है, वो किसको पकड़ रहा है? और उस सिस्टम को, उस व्यवस्था को, उस पूरे के पूरे, जिसको हम कहें कि एक जो ऊपर से नीचे तक की एक हायरार्की बनी हुई है, उसको प्रोटेक्ट करने के लिए हम लॉज का सहारा ले रहे हैं। और जब हम उनको ले रहे हैं तो उसके फिर बेनिफिशियरी पैदा हो रहे हैं सोसाइटी में। वो जो बेनिफिशियरी हैं वो कहते हैं कि नहीं, वो लॉज बने होने चाहिए। उन लॉज के लिए एक आदमी इधर से प्रो कॉन्स दोनों तरफ से खड़े हो गए, और फिर एक विशियस साइकिल क्रिएट हो गया। एंड वी आर नॉट एबल टू क्रिएट पैरेलल वर्चुअस साइकिल। और जब हम वो नहीं कर पा रहे हैं तो उसी के पक्ष में हम तर्क दे रहे हैं। हमारे सारे लॉज का हम चाहे उसको बनाने की बात कर रहे हो, रिपील करने की बात कर रहे हो, हम क्या कर रहे हैं, हम उसी इकोसिस्टम को अलग अलग तरीके से हम परिभाषित कर रहे हैं। हम नए इकोसिस्टम की बात नहीं कर रहे हैं, हम जिसको हम कह रहे हैं कि जो बेनिफिशियरी नहीं उसको सिस्टम में लाने की बात नहीं कर रहे हैं। तो जो आपका सवाल है ना, वो वहीं जाकर वहां पॉइंट आउट नहीं कर रहे हैं। और ये उसमें इग्नोरेंस कह लीजिए, उसमें अपना वाला बेनिफिट कह लीजिए। अब अगर कोई सरकार, मतलब मैं दिल्ली सरकार के संदर्भ में मेरे लिए बड़ा आश्चर्यजनक है, क्योंकि वो तो आईआईटी का पढ़ा हुआ है। भाई हर दूसरी बात में वो कहते हैं ना कि ये तो हम तो आईआईटी के पढ़े हुए आदमी की सरकार में यही नहीं पता कि कौन से लॉज कहाँ इंप्लीमेंट हो रहे हैं, हमारे हिस्से में क्या है, एमएचए के हिस्से में क्या है, सर्विस किसको, मतलब ये बड़ी सामान्य सी बातें हैं। तो इसका मतलब ये हुआ कि ऐसा नहीं कि सब उनको पता नहीं है, पता है, ऐसे ही चलने देना है, उसका एक बेनिफिशियरी सिस्टम क्रिएट हो गया है, वो उस लॉ को बदलने नहीं देना चाहता।
100% सर। पहले क्वेश्चन ले लेते हैं, फिर क्रॉस क्वेश्चन के लिए भी इसको बन जाएगा।
मेरा सवाल आकाश से है, बट बाकी पैनलिस्ट भी अपनी विशेष टिप्पणी दे सकते हैं। सवाल ये है कि आकाश वाज सेइंग इफ थिंग्स आर ऑन द वेबसाइट, शुड वी, फॉर एग्जांपल इफ देयर इज समथिंग मिसिंग देयर, क्या ऐसा माना जाएगा कि वो कानून आज की डेट में एग्जिस्ट नहीं करता? बट इंडिया कोड नाम की जो वेबसाइट है वो तो सरकारी है, और वहाँ पर जो कोड है वो माने जाने चाहिए कि सरकार ने अपलोड करे हैं तो दे आर इफेक्टिव। बट ऐसे हज़ारों इंस्टांसेस हैं जब मैं कोई केस प्रिपेयर कर रहा हूँ और इंडिया कोड का मैंने कोई एक्ट पढ़ा और मुझे पता है कि लेटेस्ट एक्ट कुछ और है लेकिन वो पुराना डला हुआ है, या उसके जो सब रूल्स हैं या वो नहीं है, तो क्या मैं ये प्ली ले सकता हूँ किसी कोर्ट में या किसी केस में कि in the India code website says this and that particular section is in my favor, the newer section is not in my favor, which is not there on the website, so क्या मैं ये plea ले सकता हूँ? और दूसरा बात ये, ऐसा क्यों नहीं हो सकता या क्यों नहीं माना जाना चाहिए कि अगर कोई ऑफिशियल वेबसाइट है और उसमें कोई त्रुटि है, कोई खराबी है और वो मेरे फेवर में है, तो वो मेरे, बिकॉज जब तक ये आप सैंक्टिटी नहीं देंगे तब तक लॉ सभी को जो पता होना चाहिए, जो माना जाता है, वो तब तक नहीं हो सकता जब तक वो आज की डेट में कम से कम इंटरनेट पे नहीं है, बिकॉज देयर इज नो अदर वे टू नो द लॉ एक्सेप्ट फॉर इंटरनेट। और गूगल, फेसबुक, ट्विटर जब इतनी हाई एक्यूरेसी रख सकते हैं अपनी वेबसाइट्स पे, वो हर सेकंड में अपडेट होते रहते हैं, तो वैसा ही कुछ अगर सरकार खुद नहीं बना सकती तो आउटसोर्स क्यों नहीं कर सकती, सो दैट the website should be the law, the authentic version which is there should be treated as law, and if it's not there then it is sarkar's fault, not mine, and they should pay the price. Thank you.
Way answered your question, but yeah, technically of course you can't take that defense because again, going back to the first line, I said ignorance of law is not excuse, and you have to find what the law is. So these two lines actually go simultaneously. Technically it's an official gadget. Anything which is published in official gadget is the law, and that's the point I was trying to make earlier also, that if at all we are asking for a central repository, a place where it is there, that will be a question to answer. Like if by virtue of law we say that if nothing is mentioned in the law, like whatever is mentioned on that website is the official version, or it will be a state promoted. So that will be a call. So there have been certain jurisdictions we actually have, like for example, if you go and check a law in UK, you can actually check the transition. They maintain a very nice timeline wherein they mention that if you go, what was the law in 1940, you click 1940, then tell you the version of the law that was back in 1940. And when you say you click 2024, they'll show you the version of the law today. So that's an IT evolution that actually needs to happen. And of course, that might be an ideal scenario, but what is more important is that exercise. Because as we have been discussing with the panelists also, that today we are at a stage we are trying to identify. As sir was mentioning, there are commissions which are actually being made to identify what the law is. So once that thorough exercise is done to identify firstly what are all the laws, and parallelly the process of repealing goes on, then that repository can actually be maintained, and that should ideally be a specific project that should be undertaken. India could of course try to do that. So for example, there is certain, if you go to certain regulatory bodies, they try to maintain updated laws on their websites. But all that is basically for communicating to the public that what the law is. Technically today also, if I want to find an answer that which is the law in place, I'll have to go and check the gadget, because that is the place where once the law is approved, then it is notified, it is come into effect. So until unless those laws are changed, these questions will still be there. Yeah, I hope that answers it.
Next question, that side.
Hello.
See, I'm sure you would be aware of several Supreme Court judgments, not directly on this point, but somewhere covering what you just mentioned. Supreme Court has unfortunately taken very conservative view on these aspects. There have been laws for decades which were never brought into force, but they were applied at some point in time. So the aggrieved went to the Supreme Court and said that these laws were lying dead. Why they have been applied after 3 decades on me. So Supreme Court said that just because the laws were lying neglected does not mean that they were dead. They could be invoked any time. However, we would give you relief provided you are able to prove that what is provided in the law, contrary to that, has also been applied in some cases. So you don't only have to prove that they have been lying dead, you also have to prove that the contrary position has been established as well. So there are dual components which you have to establish, in order to in order to disregard the so-called dead laws or obsolete laws.
Sir, गुड इवनिंग सर. सर माय क्वेश्चन फ्रॉम द हर सर. सर हम लोग इतनी बड़ी बड़ी बातें बोल रहे हैं कि सुप्रीम कोर्ट में ये वो. सर अगर हम लोकल कचहरी में भी जाते हैं तो भी सर वकील जो 10 रुपये का काम है 300 रुपये में कर रहा है. तो सर अगर एजुकेशन सिस्टम में हम सेक्स एजुकेशन एंड ऑल बहुत सारी बड़ी बड़ी जो वेस्टर्न फिलोसफीज़ हैं, जो भी लिबरल लोगों का ऐसा अगर बोलते हैं कि हम एजुकेशन सिस्टम में लाना चाहते हैं, तो सर क्यों नहीं साइन कॉस थीटा एसिड बेसिस बेफालतू की चीज़ हम पढ़ जिसका हमारे लाइफ में कोई काम नहीं है. सर बोले भी कि लाइफ एंड लॉ रन बाई साइड बाई साइड. सर कुछ नहीं सर, जो कुछ कॉम्प्लेक्स चीज़ें हैं जो लॉ में, अगर हम शुरू से एजुकेशन सिस्टम में ही शुरू से अगर हम लोग को पढ़ाएं, जो कॉम्प्लेक्सिटी जो हम लोग को जो मूर्ख बना रहे हैं सब ये वकील जो सब सर कचहरियों में सब, मतलब हम लोग खुद उन सबको कुछ नहीं पता है, लेकिन उसके बाद भी अगर हम लोग को सब बेवकूफ़ बना ले रहे हैं, अगर हम एजुकेशन सिस्टम में उस चीज़ को ला दें, अगर जो यंगर जनरेशन आगे निकलेगी उसको ये चीज़ें पता रहेगी, तो इस बारे में आप क्या सर, गवर्नमेंट को इस बारे में क्यों नहीं कुछ सोचना चाहिए?
आपने शुरुआत ये कह के करी कि वो 10 रुपए का काम 300 रुपए में करते हैं. इट्स अ वेरी रिलेटिव स्टेटमेंट. किसी किताब में लिखा है कि वकील 10 रुपए के 300 रुपए ले रहा है. डॉक्टर आपको 10 रुपए का भी मिलेगा और 30,000 रुपए का भी मिलेगा. चॉइस आपकी, आपको किसके पास जाना है. आपको अगर 10 रुपए वाला वकील चाहिए तो आपने अच्छी तरह देखा नहीं, 10 रुपए वाले भी बैठे हैं. तो ये कहना कि 10 रुपए का काम वो 300 रुपए में करता है इज अ वेरी फ्लाइंग स्टेटमेंट. हाँ, ये बोलना चाहिए था. आपने ये नहीं बोला है. आई एम श्योर इट इज रिकॉर्डेड. आपने बोला है कुछ वकील ऐसे हैं जो 10 रुपए का काम 300 रुपए में करते हैं. तो ये आपको ये बोलना चाहिए था कि स्टैम्प पेपर जो 10 रुपए का वो 300 रुपए में बेचते हैं, वो डेफिनेटली चीट है, फ्रॉड है.
नहीं देखिए, वो कोई वकीलों पर टिप्पणी नहीं थी उनकी, वो सिस्टम पर है. और वो सिस्टम मतलब 10 रुपए का काम है 300 रुपए लग गया तो परेशानी की बात है. वो किसी वकील को पर्सनल नहीं था. लेकिन ये सीरियस है. और आपने जो कहा ना, एजुकेशन सिस्टम में लाने की कोशिश तो हो रही है, लेकिन आप समझिए कि आईपीसी कब की थी? 1860 1850-60 जब की रही हो. 2024 में आ पाया बीएनएस. आप इस देश में रिफॉर्म की स्पीड तो देखिए. और अभी जब हम कह रहे हैं कि क्या क्या चेंज होगा, तो चेंज बहुत कुछ हो रहा है, लेकिन चेंज ना हो उसके लिए जो, फिर से मैं कहूंगा तो अभी बेनिफिशियरी ग्रुप है, वो वकील भी है, डॉक्टर भी हैं, पत्रकार भी हैं, क्योंकि उनको उससे बहुत कुछ, मतलब ना तो उनको नया पढ़ना है, ना नया सीखना है, जैसे चल रहा है वैसे चलना, और वो बड़े बने हुए हैं. तो इससे अच्छी स्थिति हो सकती है क्या किसी के लिए? तो एक तरह से एक पैरेलल मोनार्की सिस्टम चल रहा है. विद इन डेमोक्रेसी, इसलिए वो नहीं ध्वस्त होगा इतनी जल्दी, लेकिन वो टूट रहा है ना। हम बहुत सी चीजों पे अब चेंज होता हुआ देखते हैं। और कचहरी की बात थोड़ा सा आपने की तो एकदम अलग है, वो तो देखिए काम क्या है, कैसे करा दिया। अब जैसे ये बार बार मैं कहता हूं भाई कि किसी एक मसले पर, मतलब ठीक है कोई बहुत कॉम्प्लेक्स केस हो तो बात अलग है, वरना जमानत मिलेगी और नहीं मिलेगी इस पे तो वकील लोग फ्रॉड ही करते हैं। ये तो मैं मतलब कह रहा हूं, ये इस पर कोई चाहे तो मेरे खिलाफ केस भी करे, क्योंकि अलग अलग मसले में हो। और आप कई बार तो यहां तक देखते हैं, हाँ जनरलाइज नहीं कर सकते, ठीक है जनरलाइज नहीं कर सकते, लेकिन ये बड़ी सीरियस प्रॉब्लम है। आप सोचिए कितने लोगों को सुप्रीम कोर्ट रजिस्ट्री में पहुंचने के लिए नहीं, हम स्पेसिफिक बात कर रहे हैं, एक्सेस टू जस्टिस सही नहीं, मतलब वो अलग है, लेकिन वो लॉ से ही जुड़ा हुआ है। तो ठीक है आपकी बात ठीक है, हम सब प्रेशर बनाएंगे, कोशिश करेंगे तो उस तरफ बढ़ेंगे, मुश्किल है थोड़ा रास्ता।
Do we have final 1-2 minutes? One last minute. तो ऐसा करता है, आंसर का तो नहीं पता, but because people are raising hands, at least let's hear their questions. We decide हम आंसर कर सकते हैं कि नहीं, तो सबके आंसर तो ले लेते हैं, सॉरी सबके क्वेश्चंस ले लेते हैं, सॉरी। हाँ 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 हाँ, तो सुन लेते हैं सबकी, yes. And keep it pointed and short, please. Huh?
So one thing that I'll ask is, in relation to what was shown in the video, the Bombay Prevention of Baking Act, we have seen similar things in the US as well. And it was also said in the video that US or the developed countries have a better process of repealing these laws, right? Now if we see panhandling and solicitation has been regularly been criminalized by the local councils, the village councils or the townships or the cities through ordinances. But the US Supreme Court has said that panhandling at the very least or begging at the very least is freedom of speech, that you are asking, I'm in need of help, give me help. So that is at the very least freedom of speech. But still the laws exist, even in a developed country like US. Now my question is, it's a very simple question, but how do we make sure that the repealed laws are actually repealed?
Good, thank you very much, very good question. Yes. Mic में जरा बोलिए.
In my perception, I think appeal is the secondary thing. First thing is that we must have a effective legislation, and it is very much evident that in today's scenario, all the most probably the lawmakers are lawbreakers. So I think there is a need of a law that is needed for it. So what's the perception on it?
Okay, thank you. The third, fourth, fifth and sixth we take and just wrap it up.
सर मेरा एक सिंपल क्वेश्चन है कि सिर्फ लॉ को सिर्फ टाइम के हिसाब से बदलना चाहिए कि सोसाइटी का नीड के हिसाब से देखना चाहिए, क्योंकि इंडिया एक डाइवर्स कंट्री, तो कुछ जैसे मैं एग्जांपल तौर पर कहता हूँ कि जैसे नालसा यूनियन ऑफ इंडिया के ट्रांसजेंडर एलजीबीटी कम्युनिटी के राइट्स के लिए सुप्रीम कोर्ट ने कैबिन नप्ते सिंह चौर उसके बाद, बट देखा गया कि अभी तक बीएनएस और हिंदू मैरिज एक्ट, सोशल मैरिज एक्ट में अभी इसके लिए कुछ प्रोविज़न अमेंडमेंट नहीं हुआ। तो ड्यूरिंग दिस पीरियड 14 से लेकर अब तक जो उनके साथ जो लिबर्टी कटल हो रही है उसके लिए गवर्नमेंट कुछ मतलब क्यों कुछ नहीं करती? प्रॉपर तो टाइम से इलेक्शन हो जाती है, ठीक है, प्रॉपर टाइम से सब कुछ हो जाता है, बट एक्चुअल जो पीपल जो सफ़र करते हैं, ठीक है, तो उसके लिए गवर्नमेंट अभी तक कुछ स्टेप क्यों नहीं ले रही?
Okay, thank you for your question.
Hello.
Next.
Yes. So recurring theme that I noticed in all of the panelists' speeches was this gracious acceptance that there's a disconnect between the intricacies of law and the common populace. Not only is there difficulty in accessing this knowledge, but there's a great deal of apathy. And in this context, this entire process of reviewing and repealing becomes monopoly of the legal intelligentsia. So my question is, in this context, does this open up a space where there is potential, where there's a potential for this entire process being overtaken and being harnessed for personal gain, where this judicial review or judicial activism develops or devolves into overreach for personal gain?
Thank you. Next question.
Yeah, my question is
Final questions, and then
okay.
we wrap it
So
up.
one question and one suggestion. So my question is, like, since we have been discussing a lot about the legal information gap exists, and there is an act called the Right to Information Act 2005. Since we have a very clear act in place, so I think we have to first review the Right to Information Act so that all this information will become in the public domain. And the second thing, I'm coming to that question, maybe the way he put that question is might be wrong, but the intention is like whether there is a solution to bring a kind of a legal knowledge in the education system where it could be a part of a curriculum, right? Since CCS has been working a lot in the education field also, like different curriculum, blue curriculum and all, really there is a need to bring this legal knowledge as a part of education system so that anyone has access to the information and has the basic capacity to deal with the situation. So that's my question and a suggestion.
Thank you. And final question. Okay, perfect. I think we got many very good questions. This requires deliberation. I would suggest catch the speakers as soon as we wrap it up, and if they have time that permits, outside over the coffee.
कंक्लूडिंग रिमार्क मैं एक दे देता हूँ क्योंकि बड़ा ज़रूरी है वो। ये हम लोगों ने इतनी बातचीत की तो ऐसे लग रहा है जैसे लॉ बड़े ख़राब हैं, लॉयर बड़े ख़राब हैं, कोर्ट बड़े ख़राब हैं। इस देश में हमें अगर जस्टिस मिल रहा है तो उसमें लॉयर्स का, कोर्ट्स का और इन लॉज का भी बहुत बड़ा योगदान है। लेकिन बहुत से लोग उसको मैनिपुलेट कर रहे हैं। कॉमन सिटीजन को उस तरह से एक्सेस नहीं है, जिसकी वजह से ये एक लोगों के मन में गुस्सा है। इसलिए लॉज की भी इस तरह से बात होती है और निश्चित तौर पर जितने लॉज होने चाहिए उससे बहुत ज़्यादा है। जो ज़रूरत के हैं वो कम इस्तेमाल होते हैं, परेशान करने वाले ज़्यादा इस्तेमाल होते हैं। इसलिए नेशनल लॉ रिपील डे क्या बताया आपने, वो होना ज़रूरी है। थैंक यू।
Thank you so much, Harshvardhan ji. Thank you very much, Hemant Batra ji, Niranjan, Akash, and back to my colleague Bhavya.
Thank you. Thank you so much. Can we have a big round of applause for the panel? I'd request Snehal and some of our interns, Suha, Manas, Mishti, Satyajit, and to come here so that we can felicitate the panel. Sorry. Suha. Suha, Akash sir. Manas. Yeah. Harshvardhan sir. Mishti. Yeah. And Satyajit.
Yes, please.
We'll also take a group picture, yeah, after the felicitation.
Thank you.
Thank you.
You have more leaves, huh? Like a check, big check. Thank you.
Yeah.
Thank you so
And
much.
one for our CEO also, please. Thank you, Amit, for moderating the conversation. I would request, yeah, if we can get a group picture. As we conclude this event, I'd like to invite my colleague, Mr. Bhupinder Singh, Senior Fellow Learning and Development at the Center for Civil Society, to deliver the vote of thanks.
Hi, good evening, everyone. As we come to close of today's engaging discussion,
I think mic is not on.
is it? Yeah, okay. I want to take a moment to thank each one of you for being here and supporting this very important initiative. Your participation shows your commitment to strengthening India's legal framework and building a system that truly upholds the principle of democracy and the rule of law. The ideas, perspective, and experiences shared today have been extremely valuable and will guide us as we work to make laws simpler, clearer, and more accessible. A special thank you to our esteemed panelists, Mr. Batra, Mr. Tripathi, Mr. Johari, Ms. Menon, and Mr. Chandra, and all our scholars and practitioners for your thoughtful contribution, and to all the attendees for your active participation and your dedication to this cause. Together we are shaping a future where India's legal system not only fosters trust and accountability, but also empower its citizens. I would also like to express our gratitude to our partners who made this initiative possible in the last 10 years. Our research partners, Symbiosis Law School, Noida, National Academy of Legal Study and Research, Hyderabad, National Law School, India University, Bangalore, GNLU, University of Jammu, and our legal partner, Caden Boris, and IPFP, Vidhi Legal Policy Center. A special thank you to U Chicago for hosting us at this wonderful venue. I would also like to acknowledge and thank our amazing team CCS, Amit, Nitesh, Snehal, Vagmi, Harshita, Ravi, and our hardworking interns, Mishti, Suha, and Manas for making this event possible in very short period of preparation. Before we end, I'd like to let you know that the refreshments are arranged in the lobby area, and you will have some time to connect with each other and continue the conversation over tea and coffee. Let's keep working together to make 26th November recognized as National Repeal Law Day. Thank you once again for your time, effort, and commitment. Thank you.